Can I declare the meeting open to the public? Can I welcome members to the 81st meeting of the Committee for Justice? Can I advise members that the committee meeting will be recorded and broadcast throughout Parliament buildings and online? Can I advise members and those in the public gallery that they are welcome to use mobile phones devices as long as they are in airplane mode and all devices are muted. Attendees can also connect to the Assembly Wi-Fi and password details are available on the gallery rules. It is not permitted to take photographs or record any part of the meeting. Members will have received an email from the clerk on Tuesday to advise that it has been necessary to change the order of the oral evidence sessions today due to a change in the Minister's availability. We will hear from the Law Society first then on the sentencing bill and then from the Minister on the proposed Deepfake amendment to that bill. So can I seek members' agreement that both oral evidence sessions will be recorded by Hansard? Agreed? Agreed. Can I remind members that they are obliged to declare any financial or other relevant interests they might reasonably be thought by others to influence their approach to the matter under consideration. Any members who have interests to declare in relation to today's business should do so now or when the particular matter arises. So can I ask at this stage if members have any interest to declare?
Chair,
yeah.
Member of the AFA.
Okay, thank you. Oops, I better turn this off. And just to be complete then, that's in connection to the I had it there, it's gone. Item 8. I've lost it on my screen.
Item 8, sorry.
Item 8. Okay, any other members? No, not at this stage. Okay, agenda item number 1 is a
the usual, the all-party group.
Oh, sorry, yes, nearly forgot. The general one about us being all members of the all-party working group on access to justice. There are no apologies. I think everybody's present, or in the building at least. So, and Patsy was here, so he is due to come any time. And there are no members remotely.
Emma's actually just running a wee bit late. She's coming.
Oh, she's coming in person?
Yeah.
Right, okay. Thank you, Aoife. Agenda item number 2 then is draft minutes. Can I inform members that draft minutes of the meeting held on Thursday, the 25th of June 2026 are pages 6 to 17 of the meeting pack. Can I ask members if they are content that the minutes are a true reflection of the proceedings of the meeting held on the 25th of June? If so, I will sign. Content then?
Content.
Thank you very much. Okay, agenda item number 3 then is matters arising. Can I ask members if they have any matters arising from those minutes? Okay, so they're not here yet. So could I seek members' agreement to take agenda item number 6 then, if members are okay with that? So agenda item number 6 then is Criminal Justice Sentencing Bill, etc. Bill written papers 6.1 and 6.2 Department of Justice responses. Can I advise members that the Department has provided responses to matters raised in the Convention Rights Memorandum prepared by Assembly Legal Services and the written submission from the Information Commissioner's Office. These begin at pages 103 to 111 respectively. Can I ask members if they're content to note or if they have any comments to make at this stage? Members content? So can I seek members' agreement then to forward the relevant responses to the Assembly Legal Services and to the ICO for any additional comments they may wish to make at this stage? Agreed?
Agreed. Yep.
6.3 then, can I refer members to the response from the Probation Board providing information requested during their oral evidence on the bill, which begins at pages 122 of the meeting pack. Can I ask members if they're content to note the response or if any other information is required at this stage? Content?
Content.
Okay. 6.4 and 6.
Would it be useful just to send that to the department, maybe, that response?
Yep. Okay.
Probation board, yeah.
Yep, no problem. We can do that. 6.4 and 6.5 then, can I advise members that the committee have received 2 items of correspondence from an individual regarding domestic abuse related to suicide, which begin at page 126 of the meeting pack. The correspondence includes links to information on the campaign, and 2 letters from the Minister have been included in the meeting pack for information. Can I remind members that Women's Aid called for consideration of this matter in their submission on the sentencing bill. Women's Aid are scheduled to give evidence on the 10th of September, and it is likely that this matter may be raised then, either by them or indeed by any member of the committee. So, having said that, can I ask members if they are content to note the correspondence in the meantime? Yeah. Great. 6.6 then, can I refer members to page 135 of the meeting pack, which is further correspondence from Laura Ramsey regarding Johnny's Law. This is one of the matters raised in evidence that is not in the bill, which the committee has forwarded to the department requesting information on any work conducted or consideration given on these issues. So can I seek agreement to forward the additional correspondence then to the department for consideration along with the previous correspondence? Agreed? Agreed. No sign yet? No. Okay, agenda item number 7 then, Victims and Witnesses of Crime Bill, call for evidence proposals. Can I refer members to page 136 to 193 of the meeting pack for the relevant papers? Can I remind members that the second stage of the Victims and Witnesses of Crime Bill was completed on the 30th of June, and it has now been referred to this committee to conduct the scrutiny of the bill at committee stage. So can I inform members that today the committee is asked to agree a number of steps that are key to the call for evidence. It is proposed that the motion for the extension of the committee stage will be considered by members following the summer recess, and a draft timetable has been included in the meeting pack in the meantime, which is at pages 141. Can I advise members that the proposals for the committee's call for evidence on the bill are outlined in the clerk's memo, which begins at pages 137 of the meeting pack. It is recommended that the call for evidence is issued week commencing the 6th of July 2026, which is next week, and closes on the 25th of September 2026, allowing approximately 12 weeks for submissions and accounting for the summer recess period. So can I seek members' agreement then that the call for evidence will begin during the week commencing 6th of July and closes then on the 25th of September 2026? Agreed?
Agreed, yeah.
Mm-hmm. A draft media signposting notice to be placed in the 3 main newspapers and on the Assembly website is provided at pages 143 of the meeting pack, which is item 7.3. So can I ask if members are content that the draft media signposting notice, if they're content with that, and that goes out? Mm-hmm. Agreed? Written evidence on the committee stage of a bill is invited via the questionnaire on citizen space. A draft of the proposed citizen space questionnaire for this bill is provided at pages 144 to 158 of the meeting pack, and that is at 7.4, and will be subject to proofing and refinement prior to publication. So can I ask members if they are content with the draft citizen space questionnaire, or if there are any additional questions they wish to be included? Are members content? Okay. So can I seek members' agreement that the questionnaire is published on Citizen Space? Agreed? Mm-hmm. Can I inform members that the committee will also wish to write directly to key stakeholders to invite them to submit written evidence via the Citizen Space? A draft letter to that effect has been prepared by the committee team and is available for members to consider at pages 159 of the meeting pack, which is item 7.5. Written submissions can also be made directly to the committee's public email. Members will also wish to consider the draft list of stakeholders and expert witnesses prepared by the Assembly's Research and Information Service at pages 160 to 183 of the meeting pack, as well as a list of key stakeholders that the committee had written to request evidence on a number of previous bills, and those are at pages 184 to 193 of the meeting pack. The research officer has also advised that whilst not included in the paper, the committee may also wish to contact the Victims Commissioner for England and Wales, which is Claire Wexman, OBE. So can I ask members if they're content with the draft letter at item 7.5, inviting written evidence from key stakeholders, as well as the key stakeholders to be invited to provide evidence at items 7.6 and 7.7? Agreed? Content? Can I advise members then that the committee also normally produces social media posts raising awareness of calls for evidence to be published on the committee and the NI Assembly social media channels to publicise the call for evidence? These will be produced in conjunction with the communications team. So can I seek members' agreement that committee staff and communications team will make necessary social media posts to support the call for evidence? Agreed?
Agreed.
And then can I remind members that part 2 of the bill includes provisions relating to victims of crimes aggravated by hostility and complainants in proceedings for sexual offences. So can I take members' views on whether they wish to ask the committee team to explore holding small informal meetings to hear from victims who may have been impacted on such matters? These could be held off-site and could be with a smaller number of members in attendance rather than a full committee. I suppose with our time being very pressurised, we need to make sure we do this right, but we also need to make sure that we take a complete and thorough take on everything that we want to hear from. Victims will be important, but I just don't know what's best and how to do that. And I'm wondering, is there anybody would be interested in forming a small team, if you like, that would actually sit and listen and meet with victims? I don't think we need to do it as a complete committee, and even when they are informal, I would worry that 8 of us rock up to a meeting and start speaking to victims might be quite intimidating. So I'm thinking of meetings maybe with 2 or 3 members, or 1 or 2 members, depending on people's availability.
When are you thinking of?
Say again, sorry?
When are you thinking of doing it? What's the story?
Well, this will be September, October.
Probably starting about October, November time, yeah.
I'd be keen to do it, and I think if we just look at different availability, I do agree with you. I think maybe talking to 1 or 2 or 3 members is maybe a lot easier than the full team of us. Might be a bit more nerve-wracking and intimidating, and also might not be able to get to personally chat about those experiences as well. So I think we could. I'd be really keen to, but again, happy to let others in.
Yeah. And I suppose what I don't want either is a fragmented piece whereby 2 members go and do this one, 2 members go there, 2 members go here. If we can get a team that's prepared to do all of the meetings, or at least majority of the meetings, then you add a wee bit of consistency there. So I suppose we're looking for volunteers to say, look, if you'd be happy enough to engage, and maybe keep it that wee bit more concentrated and close, so that you maybe would have the same 5 or 6 members doing most of the meetings. You don't have to do all of the meetings. And in fact, if you only do one, that's fine. But I think we need that. We need a spine of knowledge being created, so that we can get the reports back to the full committee. Yeah.
I think it's a good idea. My fear would be, I suppose, given if some have lack of experience or something that they're around victims, that we don't re-traumatise these people, because that is something that we have to be very, very, we're not trained people to have discussions, so we have to be very, very aware of that. Because I mean, I have seen other people who went to speak to victims and they couldn't be any further from the wrong person to do that. So how do we safeguard those victims?
Yeah, sure.
I think, Chair, thank you. The TEO committee had pre-briefings, etc., for members, and actually I think for some of the victims before those type of meetings took place. I mean, this is being considered today because we have spoken to our engagement team who have some background knowledge in that kind of thing. So we would be working with our engagement team to make the arrangements for any of those meetings, and it could be facilitated as well by people within the sector, their involvement as well. So the trauma-informed approach is something that we would definitely be at the forefront of this.
So I'm wondering if there's anybody that wants to volunteer at this stage, or even give it some thought and then respond back. I think it would be useful to have your knowledge of, having spoken to some of the victims who are interested in giving evidence with regards to part 2 of the bill.
So, I mean, obviously some groups will just put in written submissions. So,
Yeah.
so this will be just those who want to give oral.
Oh, absolutely. So these are people who would be volunteering to come and speak to us in order to help us get an understanding, especially of part 2 of the bill. And it would be just, what I don't want is to bring them in, even in an informal setting, to a big crowd of us, because I don't think it's necessary. And then, of course, whatever meetings take place, there will be a report brought back so that all of the committees furnished with it.
Well, sure, if we see how many requests at those meetings, I mean, we might have to divide them up, you
Yes.
know, just time-wise, or whether we do it as a round-table event, you know, where groups come along and and members spread themselves out, you know, did that in some of the other committees. So we'll see what the level of requests are.
Yeah, well, these will be smaller, you know, more discreet, informal meetings held in a sensitive way. And that's always very hard to do, of course, and make sure that the victims are catered for. But I think it's essential that we hear, especially part 2 of the bill, and then what we're coming on to with regards to the Victims and Witnesses bill. So, you know, it's all good stuff, I think, that we need to hear. You know.
It might be useful then if we can find out who, and then we can decide, because I'm thinking at a constituency level as well, it might be useful if it's local people within a particular constituency and it's from our constituency, one with one other or 2 other.
Yeah.
So we could just be as flexible as possible.
Yeah, sure.
And see what suits best.
Are we intending to maybe formulate a set of questions which will be asked of each group as a set of questions, and I take it somebody from the Secretariat will be there as well?
Yeah.
To keep that?
Absolutely. Someone from the committee team will be there for that reason, and we can work with engagement over the summer on the type of things that you've raised. You know, if there is a set of questions, the trauma-informed approach, to maybe get a better idea of what it might look like, and then we will have a better idea to bring back to the committee in September time.
Yeah, and it's just a handrail. I mean, it doesn't stop going off to a different question, but as long as we have a handrail of questions, sure, I'm happy enough to be involved, you know, as required.
Yeah, and I'm happy to be involved, of course.
Yeah, same. I do think it would be useful.
Okay, so we had plenty of hands there with Doug, and we had Aoife, Ciara and Connie and myself, and we'll see how things pan out. But that's enough, that's sufficient, if you know what I mean, for what we're trying to achieve. And if we have to pull people in further, more people, then we can do that. Okay, thank you very much for that, members.
Yeah, you can stick me in a reserve list.
Reserve list. It's not very often that you want to sit on a bench, Morris Bradley.
I'm happy being a sub.
Okay, thank you. So finally then, can I seek members' agreement to publish all bill-related documents on the committee website? Is that agreed?
Yeah.
Are the witnesses are here?
Witnesses are here. Okay, members. So with your indulgence, I think we'll go back then to agenda item number 5, which is the Criminal Justice Sentencing etc. Bill, Law Society of Northern Ireland oral evidence session. Can I refer members to page 76 to 101 of the meeting pack for the relevant papers?
What do you think? Good afternoon.
Good afternoon.
Good afternoon. Good afternoon. Okay, can I inform members then that today the committee is receiving oral evidence from the Law Society for Northern Ireland on the sentencing, or the Criminal Justice Sentencing etc. Bill. Can I inform members that the witnesses providing evidence today is Joe McVeigh, Solicitor, Council Member and Chair of the Law Society Criminal Law Committee. Owen McKenna, Solicitor, Junior Vice President of the Society and Criminal Law Committee Member, and then Anne McMahon, Head of Practice and Procedure and Criminal Law Committee Secretary. You're very welcome to the committee. Thank you very much for your attendance. And without further ado, can I just say, members, that we are stuck for time today, because after this session then we also have the presentation from the Minister of Justice, who will be coming hopefully sooner rather than later. So if we can ask members to be concise, to keep their commentary to questions and not thoughts and processes, and can also ask the presenters if they could be concise with their answering too.
You must know me.
Thank you very much, Joe. Thank you very much. You'll have an opening statement, I'm sure.
Yes, thank you, Chair and colleagues. I am Owen McKenna, Junior Vice President of the Law Society. I am accompanied by the Chair of the Society's Criminal Law Committee, as outlined, Mr Joe McVeigh, and Anne McMahon, Head of Practice and Procedure at the Society. We were also to be joined today by Emma Lyons, a solicitor in private practice, who was going to give her personal experience of being a victim and threatened by the former partner of one of her clients. We thankfully have a statement that Mr McVeigh is going to read out in due course and present, because we apologise, but Emma Lyons has been held up with a family case in court. So after that brief introduction, if I may hand over to Joe McVeigh, please.
Thank you, Chair, members, for the opportunity to provide evidence on the issue of the Criminal Justice Sentencing Bill. The Law Society of Northern Ireland welcomes the opportunity to assist the committee in its scrutiny of the bill and to offer the perspective of the solicitor's profession on the proposed reforms. At the outset, the Society recognises the importance of a sentencing framework that is clear, fair, proportionate and transparent. Sentencing must command public confidence, must protect the public, support victims and promote rehabilitation where appropriate. At the same time, the Society considers it essential that the independence and discretion of the judiciary are preserved so the courts can take full account of the particular facts and circumstances of each individual case. A central theme running through the Society's response is the need to avoid an overly mechanistic approach to sentencing. While guidance and statutory provisions have an important role, they should not unduly fetter the court's ability to achieve a just outcome. The Society therefore emphasises the importance of flexibility and proportionality, particularly where there's not only aggravating but importantly mitigating factors that arise. The Society is supportive of measures that encourage rehabilitation and reducing offending, including the effective use of community-based requirements and these enhanced combination approaches where properly resourced. However, such requirements must be realistic, fair and capable of review where an offender's circumstances change or compliance becomes impracticable for reasons beyond their control. The Society also welcomes the bill's focus on transparency and plain language explanations of sentencing decisions. This is particularly important where offenders may not have English as a first language or may otherwise require assistance to understand the effect of orders imposed by the courts. Access to independent legal advice and appropriate interpretive support remains fundamental to the interests of justice. And in relation to offences against public workers, the Society strongly supports measures designed to protect those delivering public services, and Owen will address this issue, including legal professionals who perform an essential role in the administration of justice and the maintenance of the rule of law. The Society's response highlights the serious and growing concern about threats and abuse directed at solicitors in the course of their work and the need for robust, consistently applied protections. Overall, the Society's position is one of constructive engagement. The Society supports the objectives of clarity, public protection, rehabilitation and confidence in the justice system, while urging caution where proposals may restrict judicial discretion, create unintended unfairness, or require additional training, guidance and resources to operate effectively in practice. So that's my opening remarks.
Okay. Thank you. If I may deal with the specific issue of solicitor safety, please. Yep. And we very much welcome the opportunity to meet with the committee and the opportunity this represents to bring to your attention an issue which has been hiding in plain sight, an issue which risks undermining the rule of law. The scale of the problem is significant. The Law Society recently conducted a survey of our members in order to try and find out just how widespread the problem of attacks on solicitors has become. We were frankly taken aback by what we found. Solicitors are telling us that this problem is widespread and far more common than we might have imagined. Of the 480 solicitors who responded to our survey, 2/3 told us they had personal experience of being subjected to threats or abuse in the course of their work. The attacks take many forms, from physical assaults and criminal damage to property to online abuse and stalking. And it seems that nowhere is safe. While many attacks occur online or at a solicitor's office, others occur at or close to courthouses, and most concerning of all, some take place at the solicitor's own home. What are the Law Society doing about this issue? One of the most concerning aspects of this problem, one of the reasons we are anxious to meet with you today, is just how disappointing the response of the criminal justice system to these attacks has been. I am not pointing the finger at any one part of the criminal justice system, as sadly all of the justice agencies need to do much better. From what I have observed, I can say that when a solicitor reports an attack to the police, the response, if indeed there is a response, is often very disappointing and very disjointed. When the PPS do charge an offender, sometimes the wrong offence is charged. Many of these cases amount to stalking, and yet only 3 stalking prevention orders have been issued. And when a case goes to court and a conviction secured, all too often the outcome is a suspended sentence. The Law Society has taken a number of steps to support our members facing these situations. We have established a solicitor safety group which is developing a range of support measures, including a solicitor safety toolkit, giving practical advice to our members on how to keep themselves safe at work and at home. We are working with the Susie Lamplugh Trust to develop personal safety measures for lone workers or solicitors making domiciliary and other calls away from the office. Together with the Bar, we have persuaded the PSNI to establish a lawyer safety liaison group to better coordinate the justice system's response to attacks on lawyers. We have a specific ask of this committee. The sentencing bill contains a new criminal offence of assaulting a person delivering a public service. We are asking you to help make this new law even stronger. We ask you to support an amendment to the bill which would introduce a statutory presumption against suspending a sentence where the victim is an officer of the court, such as a solicitor or a barrister. Attacks on officers of the court risk undermining the rule of law and confidence in the justice system. The situation really is that serious. So we are asking for your support to strengthen the new offence by introducing this statutory presumption that a sentence will only ever be suspended in exceptional circumstances. We have prepared a new clause which, if introduced into this bill, would achieve the desired result. It would not tie the judge's hands. A sentence could still be suspended where the judge considers that this is the right thing to do in the circumstances of that individual case. But before doing so, the judge would have to explain why exceptionally setting aside the statutory presumption is necessary and appropriate. Colleagues, if you support the rule of law, as I know you do, you should support this change in the law so that lawyers can go about their work without fear for their own safety and also the safety of their staff and their families. Chair, that concludes my opening remarks, and I would ask my colleague, Mr McVeigh, to articulate the experience of Emma Lyons, please.
So you'll forgive me, I haven't actually seen this statement. Emma obviously was delayed, but so I'll try to read it and do a good job on her behalf. My name is Emma Lyons, and I've been a solicitor for the last 18 years. During the last 11, I've been operating my own practice on the Falls Road, Belfast, which specialises in family law. Unfortunately, my area of practice within a family law context carries inherent risk. It is often the case that disgruntled ex-partners or parents will demonise the legal representatives, and for over 10 years I've been subjected to a sustained campaign of harassment and stalking by an unhinged former partner of a client. This behaviour has had a profound and terrifying impact not only on my own life but also on my eldest child's life. The common features of the stalking behaviours I had to endure would have been as follows. repeatedly attending outside our home unannounced, causing fear and distress with my young daughter able to identify on certain occasions when playing outside. Neighbours would have made contact alerting me to his attendance, and there were occasions he would have stood for hours outside my home waiting on my arrival after work, following myself and my children during visits to our holiday home in Waterfoot, including approaching us in shops, on the beach and during daily walks, taking photographs of myself and my children while we were travelling in our vehicle, approaching myself and my children when we were in local parks, family fun days and at local festivals in Belfast, regularly standing outside my office or parking directly outside the entrance while awaiting my departure. Sometimes this was in the early evenings when it was dark and he knew I was likely to be on my own, bombarding me with threatening emails, often timed when I was alone or lodging various complaints against me or my firm to outside agencies. On 5 occasions, he had caused damage to vehicle tyres belonging to myself or staff members by slashing the tyres with a knife or sharp object or hammering nails into them. On 2 occasions, there had been smashing of windows at my office late at night, which required police attendance and my presence in the early hours of the night. I always suspected that he was behind this, but it could not be proved. Being observed lingering near the entrance and exit of my children's primary school during morning drop-off times, causing my children so much upset and fear. After enduring years of psychological warfare whereby I was in a constant state of hypervigilance and ultimately being made to feel completely unsafe in my home due to all my stalker's behaviours, I was forced to sell and move my home in 2024 to try to protect my children and myself. After countless occasions in which the above matters were reported to police, I applied to the county court for a civil injunction against my stalker, only for it to be breached within days. Eventually, harassment criminal proceedings were commenced in the magistrates' court. He was found guilty in March 2024, but appealed. His conviction was upheld by the appeal court in May 2025, and a suspended sentence was imposed with a 5-year restraining order. Despite the above, my stalker went on to torment another legal professional, which resulted in her leaving the firm she had worked in for several years. There are criminal matters ongoing that I can't discuss at this juncture. And whilst I was disappointed with the suspended sentence and felt that it did not act as a deterrent, I have never hesitated in sharing my story as I strongly feel that this case highlighted the need to ensure that those working in areas of high risk need to have better protection and stronger deterrents. A frequent question that I'm asked is why I did not withdraw from the case that involved my stalker when I was being targeted so much. The fact is my client had been continually let down by the police and the criminal justice system. She had herself endured years of abuse by my stalker. She required numerous non-molestation orders throughout the 10 years and had to defend at least 7 private law children's applications lodged by the father. This was all while she battled stage 4 breast cancer, which eventually took her life at the age of 41. I never felt that it was fair or just that she should lose her lawyer on top of all that she was battling, and remained committed to her until the end. Since the conclusion of the criminal case, I have received formal apologies from police and the PPS in respect of how my case was mishandled. It was a clear case of stalking, but yet this was not what my stalker was prosecuted for. I share my story to highlight the risks posed for practitioners and the impact that such behaviours can have on our day-to-day lives. My fear is that as these cases become more prevalent, that it will have a chilling effect on our professional independence. It will act as a deterrent for young solicitors specialising in areas that carry greater risk, such as family law, and will cause a hesitation in firms taking on certain cases moving forwards. This weakens the rule of law, and all efforts should be made to avoid such a scenario unfolding. And she's added a footnote, which is the stalker was successfully prosecuted on the 2nd of May 2025, resulting in a 5-year restraining order, the maximum available, and 4 months custodial sentence, suspended for 2 years.
Thank you very much for that, Joe, and Owen, thank you very much for your presentation too. We'll go straight into questions, but first of all, can I just add about the issue around the assaults on public workers, etc., and clause 37. and your suggestions there with regards to amendments. Can I ask, why have you went down the route of a suspended sentence? A statutory assumption against suspended sentence rather than a tougher sentence?
All sentencing options would be open to a court, but in practice to date, we have found that is quite frequently, if not always, the outcome, because if one imagines through the criminal sanctions that are available, rarely would an offence such as that attract a absolute discharge, conditional discharge. Sometimes there would be debates around probation orders, community service, but more often than not, it's a debate around immediate custody or a suspended sentence. So given that we have found it's normally a suspended sentence, we don't feel that's a strong enough message to date. And with this opportunity, we would like a stronger message that would help develop a better culture to protect those people.
And I think also other court officers, we're not singling out solicitors for this. Other court officers, including members of the judiciary, find themselves being threatened. There was one occasion, I think, just after we reopened after lockdown, where someone was found to be bringing in a bag with weapons in it to assault the district judge in Belfast. And I'm not sure about the outcome, I can't recall, but I do remember there being even a debate as to whether that should go to the Crown Court or the Magistrates Court. And I don't think it went to the Crown Court. And yet this was an assault, someone planning an assault on a member of the judiciary. So that's the real concern. The concern is, we can put it this way, protecting the integrity of the rule of law requires all court officers. Anyone who is an officer of the court, and sometimes barristers aren't, junior counsel aren't officers of the court, but we would include them in it as well. It's to prevent this chilling effect that begins to occur. People are fearful of working in certain areas of work because they know they will face aggression from people who are involved, and that has significant implications for the rule of law. And what we don't want is circumstances where there's a light touch taken to sentencing of people who make it very difficult to operate within the criminal justice system or the wider system of justice, including family law.
So let me get you back onto the suspended sentence and the statutory assumption against. And I'm asking this because of purely my ignorance. Would there be a danger that if a judge can't use a suspended sentence, that he might give a lesser sentence in years?
What we're suggesting is that the suspended sentence stays there as an option, but there's an extra safeguard in place, which is the judge has to explain why they are suspending the sentence in those circumstances rather than automatically move into that.
Yeah, and in your eyes, what would a good explanation be?
In terms of sentencing principles, exceptionality is there already throughout the Magistrates Court, Crown Court, into the Court of Appeal. So effectively, we're attaching that label to this situation, which is that there must be exceptionality in terms of the case or the circumstances of the defendant to justify that sentence being suspended. There's a list of those that are throughout the cases.
Could you produce that for us, could you?
I think we could put together a number of cases from the Court of Appeal that set it out very helpfully.
Yeah,
but it's very difficult to be precise about it.
Yeah, sure.
But there is that headline which is impressive starting point. But in terms of the detail of that, you would never want to close the doors to any aspect. But we could certainly put together a list of cases that will help explain it.
And then on the other issue, then with regard, which you did go into, Joe, with regards to the definition of what an officer of the court is. Are we in danger of leaving other people out that are involved in law enforcement, like probation board?
Well, sorry to cut across. Our view would be that anybody who's conducting their work within the system of justice falls within that. And you're right to raise the issue. I don't want to give you a nailed-on answer on this, but probation officers are officers of the court, as far as I can recall. and they should have those types of protections. Probation officers are often in a very vulnerable position because they are one-on-one with someone who may have been convicted of violence, and they have to work with people on a one-on-one basis. That's what the public demands of probation officers. And so, yes, the Law Society would say that protection should extend to probation officers.
I've centred on this range of questions. I've centred on clause 37 and the assaults on public workers. Do you think, with regards to the general thrust of this clause, that they've got it right with regards to the catch-all, or do you think, like I do, that we may need some sort of hierarchy with regards to even blue light services, people who are out there working for the public, saving lives as opposed to selling goods?
Well, up until this point, it has always been said that there's a zero tolerance approach taken to assaulting nurses, doctors, ambulance workers, and yet there are enough examples of people not being sent directly to custody for that. And so there would probably be consensus within the community that people who assault people who have come to assist them, ambulance workers, that there should be a presumption in favour of custody in those types of cases. However, you always have to have a back door to a presumption like that, because in truth, a lot of people who are being picked up by ambulance crews are people with profound psychiatric problems, addiction issues, housing insecurity. They have been maybe living on the street a very long time. They don't know help when they see it. I think we all would probably agree that people like that exist. So whilst it's easy to make statements, bold statements about how it would be that there should be a presumption in favour of custody, it is harder to apply that, and that's why the Law Society is not saying, oh, there must be, you can't have another type of outcome in a case, but there need to be some sort of exceptional circumstances. Frontline workers like that are also members of the public, and so the public have to have confidence in the way that the courts are dealing with frontline workers, and that is why the Law Society doesn't stand in the way of any proposal to have a hierarchy, as it were, of victims. I know that's become a phrase used in other circumstances in this jurisdiction, but I think in truth, when it comes down to on the street, people working on the street trying to deliver a service, I don't think anyone within the public would say that they don't recognise a need for tougher sentencing for people who are being assaulted. As I say, we always pick out nurses and doctors, but there are so many other categories of workers who are on the front line. The one thing I would say that I noticed in the bill was it's the proposed section 8, it's 38, and it sets out a list of offences, subparagraph 3.
Yep.
And unless someone has a cogent reason for it, I can't understand why section 42 assault isn't in that list. And the section 42 assault, for those who don't know, is what we used to call common assault. The most frontline workers, and I would also include solicitors in this, when they are facing offending behaviour being directed at them, one of the most common would be common assault. And now that may be the reason someone left it out, because I think, well, if it's so common, the courts will be inundated with section 42 cases where this aggravation for assaults on public workers occurs. But in actual fact, this legislation, in my respectful submission, should be to target that type of offending, to put it out of people's minds. Most doctors, nurses, ambulance crew, teachers, whoever it may be, face low-level assaults. No, yes, if someone gets their nose broken, there's a section 47 in there, subparagraph V1 VII. But in actual fact, I would have respectfully suggested that at the forefront of everyone's mind would be to curtail common assaults on public workers. So that's just one reflection I have on that particular paragraph.
Okay, thank you. I'm going to push it out then to members. Connie?
Yeah, thank you very much for coming in today. I really appreciate you giving evidence in your submission. I think we heard Emma's story at the all-party group before, and it's absolutely horrendous. And I just wanted to know what you think the wider implications of not having those protections in place are for your profession, attrition of solicitors, especially young ones, and women like Emma who are subject to abuse, but also the access for justice for victims of domestic abuse who are maybe also embroiled in disputes in the family court as well.
The Law Society, as the committee is aware, has been dealing with a considerable number of issues in this area and space anyway. The committee are familiar with the Justice Bill and the reform of taxation in the mix. Also have been very much aware of the different issues around legal aid remuneration, the criminal legal aid review and associated developments. And a massive part of the Law Society focus there was how do we refresh the available solicitors, because there has been a generation lost of solicitors who worked in legal aid because of the attacks that were made in that area around access to justice. And we have made some progress on that in terms of trying to attract newly qualified solicitors back into criminal law, in particular family law also, because of the improvements in legal aid remuneration on an interim basis, and we're hoping that there are more positive develops to come in this mandate and in the next mandate, hopefully also. But this is another challenge to that, and a more dramatic challenge in many ways, because if the supply of available solicitors is undermined on this basis, we're moving backwards in terms of access to justice, and criminal law and family law already has a supply issue, and that is a massive undermining of access to justice and the rule of law. And if we're taking one step forward on one front, it would be terrible to be moving one or two steps back elsewhere. So we are very worried about that, and that's why the Law Society is putting such a massive emphasis on solicitor safety.
Thank you. The next question I had then was around just your submission and your evidence. You'd made comments around the aggravation by hostility, and I'm just interested to know your position around including gender, and I think you'd said it may best be dealt with by a separate offence or misogynistic harassment. I was just wondering if you could expand a bit on your thinking behind that.
On that issue, I reflect upon the concept of protected characteristics. And so our society has got well used the concept of specific protected characteristics, for example, in employment law. And gender is missing. For what reason, I don't know, in this particular bill. And it may be that there's the facility to bring forward, bespoke legislation on that. But it may be a fair comment to make that there's an opportunity missed here. We do know, it's been repeatedly said, that this is a very unsafe place to be a woman. And I think it would be a brave person to argue against that. The statistics clearly show that that's the case. And there's been a particular unravelling, if I may say, since COVID. And that is why this is an opportunity to deal with that specific issue. When it comes to common assault, for example, to go back to it, Section 42 is followed by Section 43, which is assault on a woman or child. And so our laws on assault, going back to 1861, acknowledged that there is a difference between assaulting a man and assaulting a woman. Now, it may have come from maybe, I don't know, a different, let's call it a different mindset in 1861, but the acknowledgement is still there that it is a different type of offending. Women are vulnerable. The offending so often happens in their house, in front of their children, by men. And this legislation could bring forward an opportunity to make it very clear from the legislature to say we're not tolerating that type of offending by people on women. There are pre-existing issues like aggravation for assault on a woman that the courts have already used in sentencing. But one would expect that the reason we have gone to the trouble of isolating out different characteristics that need to be protected in the sentencing bill is because we suspect that maybe the application of those principles is patchy. So it needs to be specified in legislation to remind judges that they need to reflect the characteristics of certain victims in their sentencing. So I would respectfully submit that gender should be one of those characteristics. We already have it, as I say, from 1861 in some regard, but we've had it in our employment legislation as well for a very long time. And so this isn't about a culture wars issue or creating another protected characteristic. This is a protected characteristic that already exists.
Thank you. Chair, if you just let me in for one final point, and I want to say really thank you for your work on this, and I totally agree with you. It's a really dangerous place to be a woman in Northern Ireland, and I think the final point I'd like to make with the Chair's indulgence is I note that your Chief Executive, David Lavery, was invited today, but he's not here, and I was extremely disappointed to see the reference that he provided for someone who was convicted of assaulting girls, and I think someone in his position should have known better to do that. And I can't imagine what that was like for those victims to read that someone in the position of the Chief Executive of the Law Society described someone who has been convicted of those crimes as a good family man, a person of sound judgment and good character, and a Christian. And I think that is highly inappropriate and disappointing, but I also think it overshadows the good work that you and your colleagues do and the evidence that you've brought here today.
Well, Connie, thank you for that. And I think the position is that whilst you might want us to respond in some way to those comments, there is still a process in place within the Law Society that means that we cannot comment on what you've said about that. So we're not closing that debate down. We're just saying that at the moment that's not something that we can discuss.
No, I appreciate that.
We had indicated previously that our personnel committee at the Law Society will consider the issue of senior officers providing testimonial statements and the impact on victims as soon as that current process is concluded. We'd like to work collaboratively with everyone on that.
Okay, Connie, thank you, and thank you for your candour there. Thank you. Doug?
Thanks, Chair. Joe, Owen and Anne, thank you for coming along. I look at you as subject matter experts, so excuse me for any clumsy questions that I'm going to ask. But this is about Clause 2, the duty to follow sentencing guidelines, pretty much laid out by the Lady Chief Justice sentencing group. Something you said, Joe, is that things need to maintain public confidence when sentencing, and the reality is out there is public confidence in sentencing is lacking. It's waning. It's waning because they don't understand how sentencing works. They don't have that confidence in it, and the very fact is that sentencing uses case law leaves people absolutely flummoxed by the whole thing. The language doesn't work for people, and that's right. And even when I look at your response document, there's things in it, if you were a layperson looking at that, you just haven't got a clue what you're talking about. Why would a sentencing council for Northern Ireland not work? Because it works in England, Scotland, Wales and Northern Ireland in a different manner, in each one slightly, but it's still there and makes it far more transparent for people to see how sentencing works and how a sentence is formulated. Why could that not work for Northern Ireland?
Well, maybe, Doug, it's not a case of that it wouldn't work. Is it the best alternative? And with respect Obviously, when we are looking at sentencing guidelines and principles, our focus is on cases that emanate from our Court of Appeal. But we obviously look at cases that emanate from England and Wales. And I would need to be persuaded that there's evidence that people understand sentencing in England and Wales any better than they do in Northern Ireland, and that is with their Sentencing Guideline Council. The fact of the matter is, in England and Wales, they have a sort of hotline for asking for referrals, for references to the Court of Appeal. And in my respectful submission, probably most of the phone calls that are made in the heat of the moment, people very angry about a result in a case. They're not based in how the guidelines were applied. So box A goes to box B, and then C's taken into account and ends up with a result which is D. I don't think the public in England and Wales approach sentencing that way. I think people have, and this is not to patronise people, I'm also a member of the public. I also see things on the news and go, how did that happen? So as a criminal practitioner who's been around the courts 31 years on the 10th of July, I also react to what I see. But the truth is that people look at the headline figure and react to it. They don't react to how it was put together in terms of its building blocks. And building blocks is what really they have. They have this guidance, but no one's rushing to the building blocks to see how it was done. The public look at the top line and ask themselves why. That's what needs to be addressed. It's the why. It's the explanation for how we got to the point of that sentencing, what was taken into account. Now, I do think that televising courts, which is due to happen, will assist because people will be able to see the sentencing as it happens. And that will assist people. I think it assists all of us when we see it happening in England and Wales at the minute, when we see some of the sentencing that's handed down and we watch it on television. But I do think the judiciary have taken steps. For example, I think the Lady Chief Justice wants to work with court service to provide transcripts of sentencing to people who are involved in the case. So, for example, the victim receives a transcript, or I think that's the plan. And that's, to me, that's a great idea. It may sound like a bit of moving the furniture around, but it's really not, because that's a distinct move over the course of my career where victims were effectively a sideline. Now they genuinely are at the centre of the criminal justice system. Criminal defence lawyers like me can be frustrated at times because we feel, well, hold on, it's my client who's accused. It's my client who'll go to prison if they lose this case, if they're convicted. Why are they not more at the centre of the discussion? So those of us who sit in courtrooms every day see the measures that have taken place and understand that at times the defendant is not the centre of everyone's focus, despite the fact that they are the person on trial, and that there have been improvements. There's always going to need to be improvement. Our thoughts and our approaches will always evolve. But our judges are all exceptionally capable people. They've been appointed on that basis. Sometimes the public feel they get it wrong, and sometimes they do. But there's been judicial training brought in. For example, the week before Christmas this year, there'll be another week of mandatory judicial training happening. That's been happening now for the last number of years. And these issues are addressed. The Lady Chief Justice specified training, for example, the non-fatal strangulation. The Court of Appeal set down a marker on what is expected in sentencing in those types of cases. They have enhanced, they've upgraded, for example, in murder cases where the starting sentence should be. That's all reflective of the input, not only of all of you guys who make your positions on these things very clear, but the wider public. They're not immune to the wider public, and I have seen sentences creep up and creep up. Now, I don't always say the solution is always to increase sentences, which is why some of the steps that are involved in this justice bill are innovative and welcome, like the suspended sentence orders that a lawyer suspended sentence in many respects, some people may feel they're a bit of a free hit. Not to be. That they have to work through a suspended sentence. So in my respectful submission, the flexibility, the ability to respond, is baked in to a small jurisdiction like this where feedback comes fast. There's very little much of a breaker in the feedback. If you guys aren't happy, everybody knows about it. The public aren't happy, everyone knows about it, and the judiciary listen. It seems to be very clear.
And Joe, look, if I can come back on a supplementary on that, and I accept everything you've said, in many ways. But two things that you said there, which stands out. One is the fact is that victims may get the written transcript of the sentencing. But if you look at some of these written transcripts, they'll not understand it. Unless the language changes so they can understand it, you can send them whatever you want. They'll not understand it, because I don't understand it. Reading your submission, I don't understand it. So that is something that needs to change, is how the language works, whether you do that or not. But the great difference between a sentencing council and what we have here in Northern Ireland is you just simply go online. If I go online and I look at the sentencing council for England and Wales, it gives me everything. It'll go into the sentencing guidelines, research, common information, resources, everything, and it's all at a press of a button. I can't do that here. I can't get that here, and that's a concern, and that's where the public confidence isn't there. And it's not, respectively, Joe, about just increasing sentences. I don't think that's the answer all the time. But what it is understanding the sentence, and the public don't have that confidence at the minute.
Well, I agree with you on that. I don't think you get very much pushback from lawyers on that. There are two processes always going on in the case. There is the legalistic process that involves discussion and debate between all the lawyers involved, including the judge in a case. So that invariably ends in legalistic language, and it's important because that language has to be precise. It has to operate. We have to operate at a certain level, often an academic level, in order to make sure we come to the right decision. But as any criminal defence solicitor will tell you, there is a job to be done afterwards, explaining, for example, to the client what all went on in that courtroom. And so practitioners, if I may say, are very good at doing that. They make things clear for their clients. The Court of Appeal has started, and some of the Crown Courts have started to issue summaries of judgments, which I think are very useful because they have condensed, they've taken maybe a 30-page judgment and condensed it down to a couple of pages, and that's clearer. But even that maybe could be in plain English as well. So, that's, I have to say, Doug, I would accept that criticism, but I don't think a sentencing guideline council solves that, because as they say, I don't think in England and Wales anybody is running to the Sentencing Guideline Council to work out how it was applied and are they happy with the result in that context. They look at the facts of the case. If they're particularly appalling, they go, how did that sentence happen? And that's how effectively cases end up in the headlines and criticism of the judiciary happens. But in actual fact, as I say, no one's looking at the guidelines. I think our judges go to a lot of trouble to explain their decisions. Yes, they're legalistic. Yes, I can sit back. I've been reading these decisions since I was 18 years old, so I can sit and enjoy them. But weirdly, but I need a life. But the truth is that the public need to understand what was going on. But what I would say is, the Lady Chief Justice in her opening remarks when the new year, the legal new year in September of 2025, she made it clear that she's working toward making things clearer, more transparent, and I think those steps are actually being taken behind the scenes.
And one more question, if I can, Joe, and a short answer would be really useful. This one, the unduly lenient sentences in clause 2023. You've pretty much gone for agreeing that all Crown Court cases should be open to for an appeal for being unduly lenient. What's your thought on hybrid offences? Because it doesn't include hybrid offences. So non-fatal strangulation is a hybrid offence. So if it's heard in the magistrate's court, it cannot be appealed because it's being unduly lenient. Would it not make more sense to stick with where you are now, but include hybrid offences?
Well, one of the difficulties with hybrid offences is it's not, for example, the defence lawyers who decide where that goes. Hybrid offences, the decision to take that to the Crown Court, for example, is made by the Public Prosecution Service. In fact, we couldn't even judicially review that decision. So the Prosecution Service, that's sort of, in a way, I bat that across to them and say, you make that decision. If cases are in the Magistrates Court, and I think there's been a consensus that Magistrates Court cases shouldn't be open to referral, that is, in my respectful submission, an intelligent decision, because our Court of Appeal could not deal with the number of cases that might end up referred from the Magistrates Court. And so the practicalities around that, but also the Magistrates Court is meant to be summary. But when it comes to hybrid offences, in one way it's very easy. You could legislate and say that offence is no longer to be hybrid, it's to be indictable only. Yeah. And therefore it takes it out of the discussion entirely.
Mm. No, and it does. And I guess I'm using an example of the non-fatal strangulation, but before it was changed to the Crown Court, 300 of them were heard in the Magistrates Court. That means not a single one of them could have been appealed. And only 15 were heard in the Crown Court. Now I know that's changed because case law changed it. Funnily enough, so they're being mostly heard in the Crown Court. But you can still get 6 months for a non-fatal strangulation in the Crown Court, and you can appeal that. And you get 6 months for non-fatal strangulation in a Magistrates Court, and you can't appeal it. So that's why I'm saying surely hybrid, and I'll leave it there. And there's no answer needed, Joe. But I'll leave it there. That's why I think hybrid is a consideration anyway. Sorry, Chair.
No problem, thank you. Before I bring them in, Pat, I just want to remind everybody just to be concise. That includes members and you, Joe, if that's okay. You're competing against the Justice Minister, and she can talk too. So that's what we're up against today in the committee.
I was moving you along, Joe.
Patsy, go ahead.
Thanks, Chair, and thank you for your presentation here today. I want to come back to the definition of the public worker. Now, I listened very carefully to what you said. And I've looked at what your suggested amendment is with the specific officers of the court. Now, you introduced, whether it was a concept or a phrase, and you repeated it a number of times, protecting the integrity of the rule of law. So, say for example, and you have specified those people who are associated with the courts in your amendment, but then you went on to talk about PPS, then you went on to talk about, say, the likes of social workers. So, I have a question for you. Those who are protecting the rule of law, what way would you deal with the policeman who got assaulted while defending people from racist attacks?
Well, there are already separate offences for assault on a police, or they have been extended over the years, even in terms of assaults on designated persons who were civilian officers who dealt with some of the detention duties in the custody suite for the police. So there are some, thankfully, offences out there which bring particular attention to those type of situations. But some of the situations where a police officer is assaulted in those circumstances, or more generally, will then go up the criminal calendar as the injuries dictate, from that assault to a Section 47 assault, grievous bodily harm 20 or 18. But there are protections and specific offences there for a lot of that.
Which wouldn't apply to a judge, a district judge, or someone associated with the court?
Again, they could if they are at a higher level. It's back to this point about the
Do you get where I'm going here? I'm trying to establish because we've had the case made to us here about, say, blue light workers. If you hit an AD on a Friday or Saturday evening, you know what I'm talking about, right? Police officers in, and there are people there, and they may have addictions, but they're occasional actual bodily harm to other members of the public, or maybe even a police officer or a health worker. So I'm trying to get, I understand and empathise entirely with your colleague, the situation she was in, but it's just not solicitors who are coming to us with these types of situations. So how would you treat those people in terms of the sentence and in terms of how they, whenever they come before the courts?
we're not trying to be restrictive about this opportunity to change the law, and in more general terms, as is, there are
Yes.
significant protections. And I recall being involved for the Law Society in the Marnin review, Judge Marnin's review about how to deal with hate crime. And this debate that we're having now was very much at the heart of that. Does a situation need a specific offence, or is the arsenal that's available to the criminal justice system as is, or as could be developed, a better way of looking at it? And that's at the moment. If I have a client who is arrested and taken to Musgrave Police Station or wherever, and I'm told, oh, that's disorderly behaviour, and you are going, right, okay, that's at a certain level. But if the next line is, that happened at the Mater Hospital, or that happened at the Royal, or the hospital in Enniskillen or Rome or wherever, you go, oh no, this person's in a lot of trouble. And the starting point in the courts as is for a disorderly behaviour, because that's the most frequently encountered, that person's starting point with the judges would be they'll go to jail.
There, Owen, the location's one thing. Who it happened with or who the potential victim was could be quite another thing. So what case are you making there?
Well, they would that disorderly behaviour would often be in tandem with an assault on a doctor, a nurse, an ambulance driver. But that even most gentle starting points in many ways of disorderly behaviour, which might be shouting. But from there, the courts are very strong on this, that any offences involving a frontline worker would be treated very seriously.
How do they, I'm trying to get this, look, forgive me, I'm just from up the country and I'm trying to grapple with this, okay? So, how do they treat, say, the likes of the court workers that you're referring to at the moment?
At the moment, they would be dealt with as we.
The courts deal with it.
They would be dealt with under the current legislation, so it would be an assault, be it with physical interaction or a fear of an assault, and the different levels of that. And then the courts would have to decide if somebody pleads guilty or is found guilty, do they engage the probation services for a report, and they have to look at the personal circumstances of the defendant as well as the circumstances of the offence. But there are guidelines already for the magistrates court, even in terms of these type of offences that have been dealt with to help judges who are all full-time lawyers over in this jurisdiction, very different England and Wales. But the starting point would be, do I have to send this person to custody? Most likely yes, if it's those circumstances, but use the information that's available to the court to look holistically at that. And is there an alternative to custody?
Yes.
Would they be better doing community service, which is a direct alternative to custody? Or is there probation, which is more direct focus on rehabilitation? What's for the benefit of society? That's the complexity of the judge's role, I suppose.
Being very specific to the amendment that you've introduced to take you back to that. In the instance of it being a judge, a deputy judge, lay magistrate, barrister, law, etc., as you've outlined, how would the courts deal with that at present? I'm trying to get this into my head. How would they deal with it at present, and what are you proposing that it should? How should it be dealt with?
At the moment, and what we have experienced in the cases that we have encountered, the normal way that that's been approached is a suspended sentence. And what we're saying is, if that's going to be the normal approach, let's force the courts to look at this again with the foundational legislation that would say to them, actually, hold on a minute, if you are not going to send this defendant to custody, you've got to articulate and explain why you're not. If you're going to give a suspended sentence, you're going to have to work a little harder to explain that.
I'm just trying to get this into my head here, and forgive me, Chairman, but it says here, against suspending, the statutory presumption against suspending sentence where an officer of the court is a victim of an attack. So, are you telling me that in the predominance of cases where an officer of the court is the victim of an attack, that it's just a suspended sentence or up across the knuckles?
That's what we're seeing.
Is that, now, I think maybe, Chair, if we could get some evidence in support of that, that would be helpful. Maybe you can provide that.
I suppose we're basing it just to intercede there in relation to our own solicitors, our own members. At the moment,
if you had numbers, factual numbers about when that happened, how it happened, the actual case that came before, And the type of cases, the type of assault that may have been, or the type of the offence, an attack to my mind is very specific. And if those attacks were just suspended sentences, then we would need to know about that, and we would need to know the quality of justice that's being dispensed in instances where they're officers of the court. So thank you very much for that. Thanks, Chair.
Brian?
Thank you, Chair. And as was mentioned earlier, we did hear Emma speaking at the All Party Group on access to justice, and it was a harrowing account to hear, and thank you for reading a summary of what happened to her and putting that on the public domain, and we thank her for being willing for that to happen. Looking at the wording of clauses 37, 38, 39, my first concern is, would what happened to her be captured by this wording? So perhaps you can keep me right. 37 is specifically a new offence of assaults on public workers. And 38 it talks about specified offences. And as I read it, it's manslaughter, kidnapping, threats to kill, wounding, poison, explosives. And 39 again seems to refer back to that list. A lot of what Emma experienced, I'm not sure that she was actually physically attacked. It was certainly severe harassment, stalking, intimidation. She literally had to move home, and her family were affected, and other solicitors in her practice were affected. So that's my first concern. Would the wording here actually capture what happened to her?
Well,
given that is maybe more common.
Thank you for raising it, Brian, because you've reminded me to say something that I forgot to say.
Right.
I spoke to Emma by telephone before I came in, and she raised that very point that you raised, that those type of offences are not included. Mm-hmm. So whilst I was focusing on Section 42 because I see it so often for frontline workers, in actual fact she raised this issue of those specific offences that you've just mentioned not being included.
Okay.
I suppose in truth, maybe a doctor's not a GP. I'd say a GP probably is as vulnerable to that type of offending, but maybe a doctor that you meet in A&E wouldn't be, because you wouldn't know them, you wouldn't know where they were located, etc., etc. But a GP might need that protection, or a nurse in a local health clinic might need that protection. So when Emma raises it, she raises it in the context of it clearly was an offence that she was the victim of. But I can imagine other workers being victims of exactly that offence, because people know where to get them, where they're going to be. So harassing and stalking them is a very definite possibility.
Mm-hmm. Well, it's something, maybe if you want to have a look at that, if you have any suggestions on that,
Yes.
to ensure, because maybe the person made a point of not physically assaulting her, but did a great deal of harm, through the harassment, intimidation, and so on. Although there was attacks, as you said, on cars and property as well. The other point, just Chair, is just referring back to his clause 2 on sentencing. And when I read it, it seems quite laudable. Just where it says, court must in sentencing offender follow any sentencing guidance which is relevant to the centre's case, but it also gives the caveat, unless the court is satisfied that it would be contrary to the interests of justice to do so. And it goes on to talk about the guidance. Just to be clear, are you objecting to the wording in clause 2? I know people within the court system maybe want to have more discretion, but obviously you do act within, I know you're not judges, but the legal officers act within sentencing. Is there a difference also between sentencing guidance and sentencing framework? And who sets sentencing guidance or framework? Is that done by the department, or is it done by case law and so on?
Well,
or the Lady Chief
Justice. Thank you for asking. You get the prize for asking the toughest question of the afternoon. Sentencing frameworks would tend to be what Doug was talking about earlier, where there is sort of, a number of boxes that you go through, and you apply the contents of each box to the circumstances of the offence and the offender, and you come up with a decision. I would say that would be a sentencing framework. Framework sounding like what it probably is, which is rigid. Even within built flexibility within each box, you are within a framework. And so that's when guidelines become tramlines, as we often say.
Right.
And whereas if you have guidelines that are in place, and this is what I, in essence, would commend to this committee, the approach of the judiciary has been one where they have built up over the years a set of guidelines. And if you look, in that particular clause, it refers to sentencing guidelines emanating from a number of sources, and they, for the most part, are traditional sources. So, cases, judgments that have been handed down in the past, where there has been evolution of thinking, and often in response to modern thinking, modern circumstances. And also modern legislating. If we look at the offence of indecent assault and how that the sentence for that has moved over the years. In the early 70s, it was a 12-month sentence. But that has moved. So the judiciary, in step with the legislators, has changed its guidelines and guidance to accommodate new legislation as well. So I think ultimately proportionality and fairness and public confidence have always been reflected in these guidelines. But the public's approach is one of those things that maybe is the most radical thing that moves, in that the judiciary try to reflect that, I think, in my experience. So, but you're looking at the Lady Chief Justice's sentencing group. That in itself is a significant move toward bringing forward sentencing guidelines and the feed into the training of the judiciary.
Yeah, it comes. I'm just wondering how different, in the same way that the first clause sets out the principles and purposes of sentencing, which I think is helpful, having it written down in black and white. When I read that, I imagine that is more or less current practice. But anyway, it's just to understand how is that radically different to what currently happens, because sentencing has to be able to stand up to scrutiny and appeal, in any challenge, and it has to be appropriate, and command public confidence and be consistent,
Yes. I agree with you. I actually think Clause 1, subsection 2 does effectively reflect current practice.
Yeah. But I'm talking about Clause 2 itself, then on the duty to follow and give reasons in relation to sentencing guidance.
Yes, and I think that's where Doug maybe comes in, because whilst it provides a duty, one would suspect that duty is also to be clear as well, and that maybe is something that isn't imposed on the judiciary currently, and that is something where maybe the judiciary that empowers in a sense the public to go back and say, this isn't clear enough. You have an obligation to make things clear to us, and we need to understand the reasoning behind some of these decisions. Whether it's at the Crown Court or the Court of Appeal, we need to understand how sentences are. So that's maybe the change, if I might respectfully submit that, and that's no bad thing.
Yeah. Okay.
And I think, Brian, can I just add into that? Yeah. Currently, many judges do now give reasons and explanations as to why they've reached the decision they have, to try and explain it. And I think even last week at Mr. Dolan before you, and he actually confirmed that to the committee, that it was explained when the sentence was being passed, how the judge reached that and why the tariff was what it was. So I think it is happening already, and it's just a thing which is being done now. So, and I think that section 2 does cover that.
Okay, so I thought you had difficulties with section 2. But
no, not at all.
Oh, okay, maybe picked you up wrong in that. Okay, thank you.
Okay, Morris.
Thank you very much, Chair, and thank you very much for your presentation. I would like to tease out some of the concerns you have with the bill rather than the separate clauses. But there's significant emphasis placed on rehabilitation through suspended sentence orders and community requirements. Do you think that the probation board and community rehabilitation services are sufficiently funded to cope with that?
Well, sadly, so much of this comes down to resources as well as aspirational efforts to improve systems. And I would appear in the magistrates' courts every day and in the Crown Court every day, and particularly with strains in the criminal justice system as we now deal with backlogs. One of the situations that has been flagged already is, are the probation services resourced enough in the current world? And my own personal view is that probation don't have enough resources, and I know there are a number of other innovations in the mix in terms of a focus on rehabilitation, which we would all welcome for the benefit of society in particular, as well as the individuals in the mix there, be it victims or defendants. But without doubt, the like of the probation services do need additional resources. And even some of the commentary even today made me think of the police and the public prosecution service needing extra resources were required to make sure that there will be an impactful and positive outcome of some of these efforts. But probation, I'm sure, will fight their own corner. But whenever we champion investment in legal aid, for example, it would be entirely wrong of us not to look elsewhere to our partners in terms of criminal justice, and probation play a crucial role, and they certainly should get additional resources. We had an event up at Stormont in terms of the all-party group about collaboration in the criminal justice system, so we're already trying to work as best as possible as we can with everyone involved, and we would urge the proper resourcing of all parties.
Something I find up here that we correct something that's wrong without looking at the outcomes of that correction. What's the cost of that correction? So we might be able to do something in the justice bill, sentencing, etc., but we're not taking into account the long-term effect of what we have decided. And that's something that concerns me, and it's something that concerns me about a lot of the bills going through here. I'd like to take up a point on assaults on public workers. I mean, any blue light person, including the judiciary, that gets assaulted, I think the sentencing should be severe, because the sentence not just addresses the offence, it's a deterrent for somebody else repeating that offence, and I think we're losing sight of that. What are we doing to deter people from repeat offences like assaults in the judiciary, like stalking, like a whole range of different issues? The deterrent's not there, and most of the complaints I get is not about the judiciary, it's about the PPS. Why are people who have committed serious crimes not prosecuted? Because the PPS don't recommend, and it's a frustration among a lot of police officers too. So there's a lot of things that are going on in the background before we get to the actual sentence itself, even getting people to court. So what's your thoughts on that?
It's one of the reasons behind what we're urging the committee to look at today. We want to send out the strongest possible message in this opportunity in terms of deterrence, which has always been a significant part of sentencing principles, but it's about improving cultures and awareness out there, and it's very much part of our submissions. If there's a headline piece of legislation with components that specifically shine a light on certain areas, hopefully that's a deterrent in itself. But then if those need to be triggered in a court, well, then that has a follow-on deterrence for people who didn't listen in the first place. So absolutely, we would welcome strong messages being sent out where it can be. And this is a foundational opportunity for that, because after the event, of course, judges can factor in deterrence as they do every day of the week, but we have an opportunity here to shine a light at an earlier stage on how we can say these type of offences must be deterred.
Fair enough. One last small. Yep. If I read your evidence correctly, you have thoughts that the department should do more to improve prosecution practice, judicial recording and data collection so that the laws already on the statute books are used effectively. You're suggesting that some of the statute books are not being used properly. Did I pick that up right? Some of the laws on the statute books?
In terms of being related to earlier discussions, of course there is a delicate decision-making process for prosecutors, not only in terms of whether they prosecute or where they prosecute if they decide to prosecute, and you will have heard from the Public Prosecution Service representatives about the evidential test and the public interest test, and there's no taken away from the fact that those decisions are difficult and the prosecution are under significant duties in those regards. But of course, what we're encouraging is everyone please do their job properly. Because if a lot of the Law Society solicitors work in the Public Prosecution Service, a lot of the Law Society solicitors work in criminal defence, so there's a mixed membership there. But of course, we would urge everyone, as officers of the court, be it on the prosecution or the defence side, to come to the right decision. And as bodies, we would urge the like of the Public Prosecution Service, as we do, to fulfil their significant duties correctly to the criminal justice system. And they will, I'm sure, answer for themselves in terms of actions, but we can certainly encourage them in certain directions.
Your evidence certainly opens up an awful lot of questions. Thank you very much.
Okay, Emma, Deputy Chairperson.
Thanks to you all for the briefing or the response that you provided. I just had some questions following on from Connie's question around gender, like adding gender, sex. I know that there's been various interpretations as a protected characteristic, and you seem to indicate that you would be supportive of that, whereas in the briefing note you had thought that, or in the response to the consultation, unless I've misunderstood it, I took it that you thought that protecting gender would dilute the current...
Of course it could, and that is why I talked about bespoke legislation if it was required. But by the same token, this legislation provides an opportunity to do something now. Mine's much smarter than mine, could sit down and create bespoke legislation to deal with what women are facing at the minute.
Obviously in Scotland, the way that they got around that was including an aggravator for misogyny. Is that something you would be supportive of?
Yes, so long as then the definition of misogyny was clear within the definitions in the legislation. I like to think it would be given its plain meaning, and not be over legalistic or anything like that. But yeah, look, the fact of the matter is that there is a problem that's not going away, no matter how hard people currently are operating the levers to try to deal with it. There are insufficient levers to deal with what you might want to refer to as misogynistic crime. So we need to create new levers.
Yeah. So I think that's something we would be in agreement with. So I was just a wee bit confused. So that's helpful that you've clarified that. And then I suppose the other question that I had then was around a similar perhaps confusion that I had around how you dealt with including vulnerability. So in terms of adding vulnerability into the protected characteristics in the hate crime, you thought that would blur the lines, but a separate aggravator on the basis of vulnerability, as long as the legislation is clear, is something you'd be supportive of.
Exactly. One of the things about legislation is we've been talking about how this at the sentencing end we need to have clarity. But when I sit down to advise a client who's been accused of one of these offences, I also need clarity.
Yeah.
I needed to be straightforward to that person. Why? Because one of the things that criminal defence lawyers do, which the public don't always get, is we help a person make probably the most significant decision they'll ever make in their life. which is to accept responsibility for something that is very likely to send them to prison, and maybe potentially for a very long time. And so part of our job is not always to win cases, but to help people come to terms with the facts of the case and the case against them. And knowing clearly what the law is helps us. Knowing clearly what the law is helps them, and particularly when it comes to accepting responsibility. So clarity in the law is something I always welcome. So when I say you need to be clear about what misogyny is, you need to be clear about what a vulnerability is, it is because we have an obligation to sit down with the client, often in a police station, but very much between charge and court, to try to explain to them what that law means. And the clearer that is, the easier it is for them to understand as well.
I appreciate that. Thanks, Chair.
Okay, Ciara?
Just two quick ones, because obviously we've covered a lot. So just specifically in relation to clause 19, you'd cautioned against the over-mechanistic approach to tariffs whilst guarding against double counting. Can you explain this further, and maybe what alternatives you would suggest to avoid this?
Well, guess what? I had double counting in my opening remark and I took it out. So, not that I'm editing the Law Society's response on the hoof, but what I'd say that double counting occurs when, for example, you have a drink driving offence, and maybe a significant one where a person's going to prison, and a judge maybe say, and the fact that you were intoxicated is an aggravating feature. Well, no, it's not. It's an inherent part of the offence. Mm-hmm. So we avoid double counting where we call an aggravating feature when it isn't. It's actually a part of the offence itself. Mm-hmm. And so the powers of sentence were created for that offence. So we don't then say, and I'm going to add additional time on for something that is actually already part of the offence.
Okay.
So that's how we avoid double counting in sentencing people. Okay. If that makes sense.
Yeah. Okay. Then just quickly, the second one, what concerns do you have about the potential human rights breaches on the uplifting, the application of the 30% applied to the no body cases?
Yeah. The legislation itself it's admirable in its intent. If someone is bereaved and they don't know where their family member has been left, that's devastating, and it can be devastating for the rest of their natural life. So I understand the purpose behind it. What we suggest is that there needs to be caution. And that we don't unfairly treat people who are convicted of, for example, murder because a body hasn't been recovered. Now, there are a number of things that are to be taken into account in the legislation as well. So it's not like no one's thought about how the procedure going from A to B to C to try to come to a correct additional period of time on top of their sentence. But I suppose what we're really saying is if it's operated correctly, then there may not be necessarily any great concern. But it's just we're waving a flag to say that there is the potential for this to be used in a way that is unfair. And I don't have a crystal ball, but it's just about saying this needs to be considered, this particular piece of the legislation needs to be considered very carefully to make it human rights compliant, to ensure that there's a fair trial, for example, because one of the things I'd say to you is this: there's an assumption abroad that a fair trial ends at the point at which a person is convicted. And that's not true. Your entitlement to a fair trial runs all the way through to the point at which you're sentenced. In the same way as your right to a fair trial started the minute you were arrested by police. So ensuring that the trial process, including this essential part of it, which is sentencing, in these particular cases where this really controversial aspect to the case, which is that remains haven't been found. It could lead, and this is where we are maybe concerned about double counting, it could lead to someone being sentenced for an offence where a body hasn't been recovered and not being part of the, let's say, the standard sentence that's imposed, and then having this additional bit added to it. That's the concern, and in essence, I'm trying to explain. I hope I'm clear about it.
Yeah.
So the judiciary need to say very clearly, I am sentencing you for example, the murder, and not the fact that the remains haven't been found. I'm moving on to the next part, which is the fact that the remains haven't been found. But very, very clear. And lawyers will know when they look at the tariff that has been put in place whether or not that actually has happened. So the experienced defence lawyers will go, well, you said that you weren't taking that into account, but your starting point seems high, and then you added more. So that's the type of case we'll end up back in the Court of Appeal. So it's about ensuring that the judiciary get that aspect of it right. That is probably going to, as experienced as our judges who deal with murders are, they're the top tier of our judiciary. But that is going to require, I would say, significant training for them to ensure that they get that right. Or what's going to happen is it's going to be tested in the Court of Appeal, and that's when we're going to get a sort of a definite position on how that's all to be handled. So hopefully Ciara answered that.
Oh no, that's fine. Yeah.
Okay,
Thank you.
Ciara, thank
Yes,
you.
thank you.
Joe, Eoin and Anne, thank you very much for your presentation today and your time with us here. It's been a very good session, a very informative session, so thank you. I'm sure you'll be keeping an eye on our deliberations as we go forward here on this bill. So again, thank you. Thank you for coming.
Thank you, guys. Thank you very much.
Okay, members, we will move on. Agenda item number 4 then is Criminal Justice Sentencing Etc. Bill, the Deepfake Amendment, and we have the Minister of Justice in front of us, who should be outside.
He's allowed. What? He's allowed.
Okay, can I refer members to pages 19 to 75 of the meeting pack for the relevant papers? I inform members that today the committee is receiving oral evidence from the Justice Minister and the departmental officials on the proposed Deepfake Amendment to the Sentencing Bill.
Good afternoon.
Good afternoon, Minister. Thank you for your attendance. Sorry if you were waiting outside too long there.
Not at all. Mr. Chairman, we are very appreciative of you showing flexibility as a committee to let me be able to come in later today, so happy to wait. I just didn't want to let you down, having promised to come to discuss this, and I knew it was the last committee of the session, so I didn't want to inconvenience you, but I do appreciate you making accommodation for us, so thank you.
Okay, Minister, just for the record, we have Naomi Long, Minister of Justice, Andrew Dawson, Director of Criminal Justice and Legislation Division, and Lorraine Ferguson-Coote, Head of Criminal Policy Unit. So you're all very welcome here to the committee, and welcome you, Minister, and your officials, and just to invite you then to make an opening statement. Thank you.
Well, first of all, thank you for the opportunity to meet today, and obviously it's specifically to discuss the provision for criminalising non-consensual sexually explicit deepfake images. And I'm very grateful for the committee's continued support on the issue and commitment to work constructively with the Department to progress legislation in this area. I'm hoping that our discussions today will also be helpful in terms of being able to move forward positively. As members know, it had been my original intention to table relevant provisions as an amendment at consideration stage of the Justice Bill. However, regrettably, the time needed to work through the complexities which have been thrown up by Office of Legislative Counsel when they've actually started the drafting of this to ensure a sound legal and ethical basis for the new offences meant it couldn't be done. The only way we could have done so was to delay the consideration stage of the Justice Bill actually into the autumn term, which, given that it took up, I think, a record 8 days in the Assembly, that is unlikely to have been afforded to us had we waited. So I think that was the right decision, was to proceed. I do, however, want to ensure the protections for victims, predominantly women and girls, from these behaviours are provided in the current mandate. Proliferation of online abuse, I think we're all aware of, and particularly these kind of despicable images increase year on year at quite an alarming rate. And the impact on the victims, whilst it is their image but not them in the videos, is nevertheless absolutely devastating. And some people just do not recover from the shame attached to those images being circulated. They are another form of sexual abuse that I believe needs to be tackled, and as I indicated in my most recent correspondence to the Chair, I am aiming to table draft clauses as an amendment at consideration stage of the Criminal Justice Sentencing Bill. As you know, it may have been possible to do this at further consideration stage of the Justice Bill and then have an exceptional consideration stage at the end. However, that would have denied the committee an opportunity to look at these clauses at all. And I actually, from a departmental point of view, would welcome the committee's reflections on this legislation, just given its complexities. And so I don't believe that would be a good way forward. I think that the sentencing bill is still offering timely provision of the protections, but also more effective scrutiny by the committee than the alternatives. As you've highlighted, inclusion of the provision in the sentencing bill is a matter for the Speaker at the appropriate point and his determination on whether it falls within scope. I'm hopeful that it does, and I believe that I can make a strong case in that regard. I realise there are some uncertainties, and so I'm happy to discuss the proposed approach and legislative alternatives with members, but I hope you'd agree that it is a significant issue and significant enough to warrant legislation in this mandate by whatever means we can do so. You will be aware that one other alternative would be a standalone bill, and having discussed that with the Chair and Vice Chair, I would prefer if we were able to do it as an amendment to the sentencing bill, purely because I believe that given the amount of work that the committee has in front of it over the next while, to have to take on a sentencing bill with all of those stages separate would actually be quite a challenge just in terms of committee time. But it is something that we can still fall back on should that be necessary. Just turning to the complexities, as outlined in my letter on the 11th of May to the Chair, they relate to two core issues at this very early stage. The scope of the definition of the images which would be captured, and the proposals to criminalise the creation of the images, particularly the proposal to provide for a consent-based offence of creation without the need to prove motivations. That concept is novel to the existing Northern Ireland legislative framework. Issues relating to the definition mainly focus on the type of image to be captured, beyond a photograph or video, and its composition, and the scope or extent of the related behaviour to be criminalised, that is, what is harmful about the behaviour, and to what level is realism a factor in the determination of harm. Officials are working on a detailed consideration of the varying behaviours involved and the levels of associated harm. That has to be carefully thought through to ensure it's a sound and legal ethical basis to allow the new law to proceed. It's important that we avoid any unintentional consequences and ensure compliance with ECHR guidance. Those engaged so far include Article 8 rights, which is the right to a private and family life, and Article 10, which is freedom of expression. On the creation offence, of course, we want to be able to deal with those who create the images on a commercial scale. However, the availability of notification apps mean that the ease with which they can be downloaded creates a situation where this kind of behaviour is no longer a niche activity. This type of offence, which was convincingly argued for in responses to the consultation, will ensure that the scope of protections from associated behaviours is as comprehensive as possible. The reach of the offence is wide, and the consequential interference with human rights which has been engaged has to be proportionate to the harm caused and within the competence of this Assembly. I have been asked why we did not simply replicate the approach already taken in England and Wales. The reason is that I want to ensure that victims have no less protection than available for victims in England and Wales, but it's not simply a matter of replicating the provisions that are available there. It is important that the legislation is specific to the Northern Ireland context and fits appropriately within the existing legislative framework. While the England and Wales approach provides a very good basis on which to consider our legislative approach, its legislative structure around intimate images has changed over the course of the past few years, where dedicated offences such as upskirting and revenge porn have been repealed and replaced by more generic intimate image-based offences to deal with the breadth of associated behaviours. So prior to legislating for the creation of deepfake images, England and Wales already had a different framework in place for the sharing and threatening to share intimate images in a more general sense. Our legislation does not have similar provision. Their definition of intimate images, for example, covers a broader range of behaviour than simply deep fakes. During progress of the creation proposals in the then Data Use and Access Bill, ECHR concerns were raised which were allayed with the inclusion of a reasonable excuse defence. My proposals will also include a reasonable excuse defence in the consent-based offences. However, it's important to ensure that our provisions are proportionate and within the competence of the Assembly. I realise that is a brief summary of the issues, but I hope that our discussions today will help clarify some of those complexities. And before I finish, I would also like to express my regret that members have not yet been provided with a summary of the consultation responses and next steps report. Following initial analysis by officials of responses to the consultation, my intention at that point was to table an amendment at consideration stage of the Justice Bill. With very limited time and staff resources available, work at that stage focused on developing legislative instructions. Following drafters' consideration of the instructions, resources have and continue to be focused on working through those complexities. However, it is an intention that a confirmed position and workable draft of the provisions will be available for consideration by the committee in September, and a draft summary of responses and next steps report will then accompany that draft. So you will have sight of both at the same time, which is hopefully helpful to the committee. And I suppose I'm really happy just to take whatever questions you might have.
Okay, thank you, Minister, for that information. I suppose that you led on at the very end there to the question I was going to ask, and that was when would we see the full report of the outcome of the consultation? And you have explained that in some regard and some detail. But I suppose what I would say, us as a committee being able to scrutinise your amendment will be dependent on how soon we get it. And we would certainly most definitely need it for the beginning of September. But if you can furnish us with the full report on the outcome of the consultation beforehand in August, then at least that would be something that the members here could read up on before we get back to a committee meeting in September. And I suppose if there is anything that can be done, even furnish us with a number of weeks beforehand, well then that's always something.
Well, look, we'll be happy to try and do that, Mr. Chairman. I mean, the challenge that I have is that, as you will have seen with all of these bills, it's very often the same people who are sitting here answering questions. We have a very small legislative team within the department, and when we were focusing on trying to get this drafted as quickly as possible, it meant pulling people away who would otherwise have been doing that report for you. But hopefully we're now at a stage where it's mainly OLC who are working on the drafting, and that will create a little bit of space where we can perhaps accelerate the report. What I can say to you is, if the report is available before the draft clauses, we will furnish you with the report at that point. But the latest point we will furnish you with the report is with the draft clauses when they're finished the drafting with it, we'll see.
Okay. I suspect this is a very fast moving world in which you're trying to legislate in now, and deepfake is only going to be one aspect of the measures that we will have to try and put in place in legislation to defend our people, especially young vulnerable females. There's absolutely no doubt about this. So I suppose what I'm asking is, have you any intention, Minister, even in the next term, no matter who Minister is your department framed or working towards not only this specific amendment with these specific creation or offences around the creation of deepfake and everything that comes with it, a broader, larger piece that may well come in the guise of a complete bill on all things digital?
Yeah, it's interesting because I think I mentioned when we were during one of the debate stages, I think it was the Victims and Witnesses Bill around Kiva's Law and the issues there. And I think this is another area where policy is moving very quickly, not just in GB and in the South, but also we're seeing that also, I think, across Europe, where more novel approaches are being taken. For example, I mean, I would see this very much as a starter, as a starting point for these particular and most harmful images that we're aware are out there. I think that there are other things that need to be considered, and whether they would fall within our legislative competence in the Assembly is something that we'd have to look at. But there are novel approaches being taken in other jurisdictions, for example, about essentially the copyright of a person's image and the degree to which it can be tampered with without their consent, how it can be used, which would cover some of the deepfake stuff, but would also cover some of the stuff around broadcasting images of people who are in car accidents or having seizures or whatever it might be. And the exemptions that they're looking at in those cases are that if it's public interest, so that would allow news programmes and so on to be able to do that. And the other thing is for satirical purposes, because we all know that none of us would consent necessarily to be laughed at, though it might be appropriate that we are sometimes. I'm not looking at you, Doug, particularly. Sorry about that. We just made contact at that point. Apologies. So there's that, and I do think that there is a wider piece of work that will need to be done, whether here or in Westminster, around how we manage the digital space. Obviously, online communications are a reserved matter. And what we're trying to do here is fill a gap that we believe exists about the creation and sharing and so on, which falls short of us regulating the online space, but actually the behaviours. And I think that's the line that we're kind of drawing in this. But it may well be that there will be more comprehensive offences brought forward in the future, because I do think our relationship with the online world is changing dramatically. I think, we've seen it, whether it's catfishing, whether it's the theft of people's images to commit fraud, or whether it's in deep fakes and other things. There is this new space around people's personal data and images being used in ways that they have not consented to, and it is a violation of their privacy and their rights, but it's where you draw the boundaries around that don't interfere with, I suppose, normal scrutiny for politicians, normal accountability, and things like public interest, where you're broadcasting images more generally of an incident that has taken place. So that will need to be navigated. It's not something at the moment that we're looking at specifically in the Department of Justice, but I suspect it is something that will be being looked at the national level. We already know, for example, there's consideration about bans on use of certain platforms for under 16s, and a whole range of other things that I think will have to be looked at in a lot more detail over the next number of years. And we'll certainly play our part in feeding into that if colleagues in England and Wales are taking that forward at Westminster.
Okay, thank you, Minister. I'm going to put out to members. Connie?
Yeah, thank you, Minister, for coming in today, and thank you and your department for all the work you've been doing on this issue. It is incredibly complex, but also a really important policy area. I would just appreciate it if you could outline for us what work your department is doing to draw on the expertise from other jurisdictions around this.
Andrew, do you might be able to come in on that?
Sure, yeah. So, I mean, we've started looking at the England and Wales situation, as the Minister said in her speaking notes, and essentially we're taking our base offences from England and Wales, and there's a lot to learn from there. There's a slightly different scenario in Scotland, I think, Lorraine, whereby
I'm happy to sort of take this. We did look at a range of jurisdictions, so this isn't just unique to the United Kingdom. This goes further: New Zealand, Canada, Australia, United States, and they're all criminalising this particular behaviour. More locally, Scotland has a sharing offence. It has had that in for some time. The Republic of Ireland also has sharing offences in place. Now, England and Wales, there has been a particular interest in England and Wales because of the time the Minister was proposing extending the provision of the creation offence in the Crime and Policing Bill, and there has been a lot of interest around that particular jurisdiction, and also because our framework has been closely aligned with that prior to a significant change they made with their framework. more recently, which have been doing in stages. So we have considered those. We are looking at the England Wales model because that has this unique creation offence on consent based only without motivations, and that's where we have been focusing our attention at the moment. But we are also looking at other jurisdictions as part of that, because, as the Minister says, this is not just about replicating the England Wales approach. This is about making sure it's tailored to the Northern Ireland jurisdiction. For example, sort of going on a little bit, but the definition, perhaps in the England Wales, is wide, unintentionally so, we think, as our interpretation. But their definition incorporates other behaviours like revenge porn, upskirting, downblousing, and now deepfakes. So we have to look at that critically and make sure that the behaviour that we're seeking to criminalise is proportionate. So our original consultation had set out looking at the inclusion of the motivations, but this creation offence, which is unique in a sense to have some creation on a consent base, sharing on a consent base in Republic of Ireland, but England and Wales is the jurisdiction where this is unique to this particular jurisdiction, and that's the one we're centering our focus on.
Sorry, I was going to just say around the creation offence in Scotland, they've done some consultation on this, which closed earlier this year, but they haven't reached a conclusion in terms of the creation offence yet as to how they're going to take it forward. So the only local comparator that we have in these islands is really the England and Wales option, though we are obviously looking more widely to see what's happening in other jurisdictions. I think because of our similar legal systems, it makes sense for us to look at England and Wales and the South because they're based on the same kind of common law principles. But nobody else has yet kind of gone to the kind of creation offence other than in England and Wales. So that's kind of the one that we've been relying on most.
And the only other thing I'll add is that we, I suppose, get additional assurance when we look at European jurisdictions, because their laws will have needed to comply with the ECHR, which again is going to be important for us to make sure that anything's within the competence of this Assembly too. So we get additional assurance from that as well.
Oh, thank you very much.
Okay, Connie, thank you. Doug?
Thanks, Chair. Minister, thanks very much for your information. I think this is a really important issue to deal with, and it is going to be fast-paced. I've two questions. Well, the first one is really an observation, and I would ask you to look at this if I could, please, Minister. And it's around terminology. I've never liked the term deepfake, because the term deepfake was coined by an individual who was a perpetrator of image-based sexual abuse. So we're actually promoting something he started. And it was on Reddit, and he actually opened a file, our Deepfakes subreddit, and we're now using that. Now, speaking to some organisations, they've said that sexually digital forgeries might be an alternative, and you've probably heard this already. Could I just ask, Minister, that you look at maybe change that? It may be too late for us, because we're using it as a descriptor, as a simple descriptor, but if we can change that terminology, I think that would, if that's useful.
Yeah, I mean, I think this is something that could come out of the drafting process as well. Whenever we speak to the drafters, they will, I suppose, come around to a form of words whereby we may not use the phrase deepfake because it doesn't fit with what we're actually ultimately the result we're trying to get. So certainly
other jurisdictions use
if I could just add to that, it's actually something that we're working with the drafters on. It's not a particular title that we would be looking to. It's just one that's very commonly known across the world. So that's sort of how people, like revenge porn isn't
we haven't used that either in the legislation.
No.
But we understand the terminology that it's kind of common parlance. But I would imagine even in terms of what we would be describing behaviours and actions that people are taking rather than giving it a name. But we can certainly look in terms of the drafting, and if it is, sex-based, image-based, sexual, digital forgeries, whatever it might be more than happy to look at the language around it, because I do take the point that at some level deepfakes also I think sounds a bit trivial in terms of what we're actually dealing with, and I think recognising that it's image-based abuse is quite important, even if that is digital forged images that are being used. So yes, we will look at that, definitely.
Thanks, Minister. And the second one is maybe to get your thoughts on the intent piece again, because I didn't quite pick up on that, because on the legislation we're proposing, there has to be an intention to cause humiliation, alarm or distress to a person depicting the image. However, just the creation of the image automatically does that, whether you have an intent or not. Is that something you're going to look at, or is there a particular difficulty in that issue?
Well, there has to be a defence, and we found this in order to be proportionate, we have to allow people to have a reasonable defence that they can use, and this happened, I think, in the England and Wales situation. So if you don't allow for that, that brings us into potential conflict with our own scope of legislation and our competence to do it. The inclusion of the two motivations in the sharing and creation offences enables a distinction to be made between the nature of offending, and one of the reasons that that's important is that it matches Northern Ireland's sexual image offences more widely. So, for example, on voyeurism, that will be dealt with.
Ciara was going to break into song there.
So, apologies. You're fine. They're very well recognised motivations across a number of jurisdictions and have been tried and tested by police, prosecution, and in the courts. It's also, from a public protection point of view, the rationale where it's sexual motivation is quite important in order that falls within the risk of future sexual harm, and they can therefore be dealt with under public protection arrangements, versus those who may be doing it to embarrass or humiliate somebody. So the motivation is important in two senses. First of all, that somebody can have a defence, but also that where there is a sexual motivation proven, they can go onto the sex offenders register and other things, and so that's important. I think from our perspective too, it's about making sure that it's proportional and it's proportionate, because what we don't want to do is criminalise somebody messing around on an app and doing something, and suddenly they find they've committed a very serious offence when they'd no intent to share, they'd no intent to frighten or humiliate, but whatever might have happened, if the person became aware of it, they would be. The creation offence is the one I think that I'm correct that OLC have more concern about, because they're saying that creating that offence is a much clearer cut issue. You either create the image or you don't, which is why the creation offence has been more difficult, I think, in terms of needing that balance brought. The sharing offence in some ways is much more straightforward, because once you share it, you're essentially doing it and you know it will cause fear, distress and all of those other things. The creation offence is more complex, and I think that's what OLC are really particularly keen to work through, to make sure that it is proportionate and not criminalising inadvertently activity that perhaps doesn't require to be criminalised, and that's about that balance.
And the creation offence as well, I suppose, is where it engages most on Articles 8 and 10 of the ECHR as well. So those go to the competence considerations that we're having to work through.
I guess one of the concerns is I think if the Law Commission, one of these concerns is the fact that people are using a defence that maybe it was just a joke.
Yeah, and the creation offence, so what the Minister is proposing from the consultation, is informed the consultation, is that we widen out the creation offence, not limit it to the two motivations. So we would have a base creation offence like the England-Wales model. We're not replicating it, but it's some similar approach, whereby it would just be based on consent only. Now that would bring in other motivations such as coercion, financial gain, doing it for a joke. So without any particular motivation, there were particular individuals, the consultation Professor Claire McGlynn, who you maybe be familiar with, who gave evidence to committee on upskirting and downblousing. She favoured the consent-based only, but she also did not oppose the other motivations for the reasons the Minister has highlighted: humiliation, alarm, distress, and for the purpose of sexual gratification is well rehearsed across law and across other jurisdictions, so it's not new. But this consent-based offence solely is, and that's where we need to be careful with the proportionality, because at its most basic sort of level, you could have a person sitting in their room creating a deepfake. The victim doesn't know that it exists, and there's no intention of sharing it, but they've created it. Professor McGlynn's view is that this normalises this particular behaviour, and the proliferation of its use and the easy access to the apps that are there can be accessed by anybody, and school children are using it very widely. So that's where the creation offence is, which is quite novel, and that base offence the Minister is also proposing for sharing as well, that we have those motivations as we consulted upon, but this additional offence will incorporate other motivations. But the draft person's concern is that it's getting the right balance of interference with and engagement with Articles 8 and 10. On one hand, you have the victim's right to their identity, to their private being, and on the other hand, then you have the person's right to freely express. And they weren't the only. The Human Rights Commission also proposed the consent, as did Cara Hunter, the Victims Commissioner, etc. So that was what sort of proposed.
I think the other thing, Doug, you mentioned about the idea that people might do it as a prank or a joke or a laugh, and I think the consent issue gets away from that, in that you would have to have the consent of the individual to use their image in that context. But there is a concern, and I think it is a valid one, that we need to be sensitive to, and it's why I think this has ended up being much more complicated than it appeared at first glance. In the proliferation of these notification apps, with millions of people accessing them worldwide, is now rife. The apps are advertised on social media, from TikTok, Instagram, right through to LinkedIn, and more. One of the apps, for example, in the Apple Store last year actually had prank in its title. So people would be thinking, oh, this is something fun, and downloading it. Another was referred to as a simulator joke app. And so again, it's very much sowing the seeds for somebody who's downloading it that this is a prank or that this is a joke. And so there was some concern, I think, from those who responded about capturing young people who perhaps see prank app or simulator joke app, think it's funny because it's being advertised widely online and it's available, and maybe not recognise how serious it was. But the converse of that is that you could have, for example, deepfake porn websites and notification apps using the motive requirement as a kind of get out clause of being held accountable, and saying, well, this is just fun, it's just a laugh, it's only a joke. And so I think that balance of saying, if you've consented to be part of the joke, that's up to you, and that's not criminal. But if somebody is using your image without your consent to do this and to prepare these images, then that is of concern. And then we look at the motive, I suppose, almost separate to that, and saying, now that the image is there, what is the motivation for it? Is it sexual? And if it is, how do we then deal with that person? Because there may be other sexual offending. If it's not sexual, if it's about trying to coerce or intimidate, then we need to deal with that in the way we would deal with other intimidation. So that's where it has become much more complicated, because obviously we're not wanting to over-criminalise people who naively think this is fun, but at the same time, we want to normalise it and say it's okay to use other people's images in this way. And it's a bit like the down blouse and upskirting. We were always concerned that people would use, well, it was only for a laugh, it was meant to be a prank, as a defence. And we wanted to be absolutely certain that couldn't happen, because as soon as you allow that as a defence or some kind of protection, you're admitting that you're out to humiliate somebody, because that's the joke, effectively. And that's why it's so important that we don't allow that to happen.
And Minister and Rain as well, I mean, it's fascinating, and it's complicated, far more complicated than people realise, because in England and Wales they amended the law on the Sexual Offences Act 2003, which basically means if you use AI to create a sexualised image without permission, even if you request it and don't share it, that's a criminal offence. Now, that's outside of our competencies in Northern Ireland, I believe, Minister.
I think it is, because it ties into AI distribution.
But is it something we can adopt? Is it something we can bring in, or is it too
look
wide?
at as part of this particular provision?
Yeah.
And it's something we've actually sort of stripped apart the definition and the offences that they've brought in. Their offences, they had dedicated offences like ourselves, the upskirting. They didn't have down blouse, but they do have
now, and they had revenge porn, for want of a better term. But what they did following a Law Commission report was actually an overhaul of the dedicated offences. So they have got the intimate image creation, sharing, requesting, creation and threatening to share. But the definition that they use across those intimate image provisions is fairly, this is the standard one, and this is the one that we're taking apart. So those sorts of things we are looking at as part of that.
Because supplying tools to be able to create an image is also an offence.
That would be outside.
That's outside our competence, because the actual tools themselves are telecoms, and it would be DCIT would deal with it in London. So we can only really deal with the use of the apps, not the production of them. It's also true to say that sadly, people with enough know-how can take an app that isn't designed for that purpose and modify it to be designed. It's one of those things, Doug. I mean, I'm going to show my age here dreadfully. Some of you will remember this, some of you won't. But you'll recall, as I do as a kid, the pens you used to get with the lady in a bikini, and you turned it upside down and there was no bikini. And it's really a reflection, I think, of society, that we've now found more sophisticated ways. Oh, Patsy. But it's people have found more sophisticated ways to do basically the same thing, only with real people's images who haven't consented to be put in that situation. And, you know, it was, at the time it was seen as a bit of a kind of almost like a fun kind of bawdy seaside humour sort of thing. Whereas we would see that now as a form of kind of exploitation if the person who didn't consent to the image. So I do think sometimes that it's the intent behind it that we are most concerned about, but the actual creation offence, I think, allows us to say to people, this is not normal. To take somebody's image without their consent and basically strip it bare and create a fake image of them naked, you know, even if you share it with nobody else, it's a degrading experience for the individual, and you've changed how their image is being used in a way that they wouldn't consent to. And I do think that there is that wider piece I said earlier about how some places, I think Denmark, Germany, are looking at the idea of copyright of a person's image and identity to prevent this happening for any purpose other than exceptions. And it'll be interesting to see how that sits in the European framework of human rights, because again, you could make lots of arguments as to whether or not that's acceptable. There have been, for example, debates about, for example, do these have to be lifelike images or manga cartoons of people that are recognisable as that person and then used for sexual purposes. That's something that they're looking at in other places. So it is a really complex and fast evolving area. What we, I suppose, are trying to do at this point is to ensure that there isn't any legislative loophole here in the interim, but I do think there will have to be a more comprehensive approach taken down the line in terms of how we deal with image-based abuse more generally, in terms of giving wider protections to members of the public.
Thank you, that's fascinating. Thank you, Chair.
Okay, Deputy Chairperson Emma.
Thanks, Chair, and thanks, Minister and team for coming in. I think you've given a pretty good overview of how complicated this is. I understood, perhaps misunderstood you when you were speaking, Lorraine, about the initial intention to go with the very clear intent behind this, that perhaps you were taking on board the advice of Professor McGlynn and others to try and broaden that out, but I think you've provided rationale as to why you would want to have those clear motivation. And I'm sure that's something we'll suss out as it goes along, but I suppose there is clearly a reason for that, and the need to provide people with the opportunity to defend themselves. Can I ask what engagement you've had with the Department for Education? I'm conscious that a lot of what you've raised there, particularly around the use of these apps and the sharing of images, I know I've dealt, and I'm sure everybody around the table has had constituents come to them who have been victims of this, and the perpetrators didn't understand that they were doing anything wrong, or didn't, that wasn't something that there had been conversation or discussion about. So I wonder what communication.
Yeah, I mean, to date we wouldn't have been engaging I suppose, very directly with the department, but when it would come to the point where we were bringing forward amendments, we would do so in terms of preparatory work. There would be a number of people that we would want to engage with. I mean, first of all, our justice partners in terms of preparatory work for them, in terms of interpretation of the law and all of that, and preparatory work for its commencement. But we would also want, I think, to spend time educating the public, and particularly young people, about the apps and about the fact that just because it says it's a prank app doesn't mean it's funny. Because again, we don't want to over-criminalise young people who, may be foolish and reckless and not really understand fully the consequences of their actions. And that, I think, is why, that it's almost like a layered approach that we're taking, and the actual creation offence is one offence, but if it's with a sexual motivation or something else, that's additional that would be added to it. And I think that's the proportionality part. But I mean, we have obviously raised this at executive, so I mean the minister and so on would be aware of our intention in this space, and we would need to do, I think, probably more detailed work, particularly around public awareness raising and so on, if this is to be implemented.
Yeah, I just add to that. Yes, as the minister says, we haven't engaged with, because it's quite early in the process, but we do fully intend to, and promotion and awareness is critical. Engagement with the Education Authority, but also the wider comms strategy around this. We had a particular communication strategy for the work on the Justice Sexual Offences Trafficking Victims Act, Northern Ireland, with upskirting, downblousing and cyber flashing come in, and we did that mostly in social media, and we had this an independent promotional agency were involved in that, but it is critical. It is critical.
I suppose it's just, it kind of strikes me as an obvious gap there, where if you're prefacing the offence with there having to be a stated intention to humiliate or to use it for sexual gratification or whatever the case may be, and you're saying, like Professor McGlynn has outlined, that she feels that leaves you with a threshold that's very difficult to meet in terms of proving that. But do you think that that's necessary in order that you don't criminalise people who weren't trying to do any harm to anyone? Well, if it's very clear that everyone understands the harm involved here, you sort of close that loophole, and that maybe would leave it easier to...
Yeah, and I think that there are a number of places where this probably is relevant. So upskirting and downblousing, as the legislation goes through, it gets coverage, and I think it tends to spark a wider public conversation, which is important, even just between parents and their own kids who are talking about it. There was a similar thing happened when we talked about the creation of child sexual images, and the risk that children can actually create child sexual images whilst sending messages between themselves that can actually run foul of the law. And I know a number of parents who had said that they had sat their kids down like at 12, 13 to say, just if you create an image and you send it to someone, and they pass that on to other people, and that's fine, you could be charged with creating an image, a sexual image, if it's a graphic image, and therefore you could be breaking the law, because many children won't see that if they feel they're sexting a boyfriend or somebody that they trust. And it's trying to get more awareness of that. I think that's one of the areas where, again, I think good RSE matters, of actually talking to kids about what are becoming very normalised behaviours in society. Digital footprint, people meeting online, engaging online, dating online for a while before they meet in person and so on. It can actually raise quite a lot of risks for people in terms of their long-term digital footprint. And so I do think that there is a piece of work required around that in terms of just child protection, understanding the law and where they sit within the law, and understanding when they are a victim, but also understanding the risk of them becoming a perpetrator if they cross over to the other side. And I would agree with you. It's something that certainly through the work we do with Department of Health and Department of Education and so on around trying to protect children from harm is something that we would want to be raising with them too, because it would be good, I think, if we had a coordinated approach in terms of education.
Can I just also highlight just one other minor point? This legislation is to close a gap in the law whereby, you know, deepfakes of adults, this is for deepfakes, so it could be a child over the age of criminal responsibility, you know, committing a fake, so it could be a pupil on a teacher, for example. But there's already existing law whereby...
Deepfakes of children.
Yeah, deepfakes of children, indecent images, and that covers children creating images of other children under 18, and that's in the Protection of Children Northern Ireland Order 1978. So it's not novel. You know, and that's quite comprehensive legislation as well. And what we're doing here with this is actually trying to align that as best we can as well, so that we don't have protections across the ages either, so that children already can be criminalised. But yes, I agree, absolutely. We'll have to do a wider awareness of all of it.
Okay.
Sorry.
Patsy?
Yep. just one thing on this, Minister. And I was thinking as you talked there about there are people who are knowledgeable in these things who can adapt apps and all that sort of stuff. What, if you like, enabling power, whatever it is, that you can factor into any future legislation? That now, you're really talking about future-proofing, because, as we know, the likes of AI is just developing at a fast pace that probably none of us can keep up with, even those who specialise in this field. What sort of enabling or facilitation powers can you incorporate into this to make sure that that sort of stuff, now we don't know what shape or form it might take or might happen into, as we've seen with AI, but just to prevent against this rapidly, you go through a whole long process of developing legislation for one thing, and then all of a sudden you're into a new era with new type of apps or new types of software or whatever it may be. What sort of provision can you factor in for that?
Very difficult. I mean, I had hoped during the engagement with UKG on a number of new measures for Extension Northern Ireland as part of what was the Crime and Policing Bill, to extend the new purported intimate image generator offence, which is now part of the Crime and Policing Act 2026. It's section 99. Which criminalises those who make, adapt, supply or offer to supply. So it covers adaptation for something for use as a generator of such an image, such as, for example, easy access to notification apps. Kate Nicholl has suggested that she would hope to bring a provision similar to Section 99 in Northern Ireland. And if we are able to work, because she had suggested that whenever we move our amendment, that she would bring an amendment to deal with those apps, and that would cover that same ground. So it would be very much around the making and adapting the image modification stuff. I think both, because we wouldn't have had the capacity, to be frank, to do both issues, and it was something that Kate had met with me about, because she's been doing a lot of work around AI and apps more generally. I think if we have the provisions that we're bringing forward, plus potentially that as an amendment on top of it, that kind of closes any gap that there would be. Relevant here is Section 73 of the 2026 Act, which I was able to extend to Northern Ireland by way of legislative consent of the Assembly, and that applies to child sexual abuse. So it criminalises those who provide the means to make the images. And so what, I suppose, if you make, adapt, possess, supply or offer to supply the generator or the image, you can be held accountable. And I think the intention therefore would be, as I say, that Kate had indicated that she was going to amend, if we were bringing it at the Justice Bill stage, that she was going to bring it there. So I would imagine she's done some work on this already in preparation, but she had suggested that she would bring that across, and that it would apply to these notification apps as well. And that would close, I think, for now at least, all of the gap. And anybody amending, so if anybody gets an app and they're able to amend that app and change it into an image generator, or change what the images generated can be, that would become illegal to do so. And just so that you know, on indictment, it's 5 years imprisonment, a fine, or both. So, I mean, there's reasonably stiff penalties for doing it.
So, if I'm thinking out loud, I'm trying to establish, is there a mechanism that could exist between government and, if you like, the private sector, which is developing all this stuff, whether those are the big computer companies or Apple or those, to make sure that one is keeping pace with the other? That type of approach. Now, I
Yeah.
don't suggest it would be for your department.
No, it would be for
UK
telecoms.
government,
It would be
right.
decent and telecoms, because it would be for them obviously to negotiate with the providers of the apps and the companies. Also, Ofcom have a role in this because, well, Ofcom, because they will look at the publication of stuff online, and if they're aware that the generating tools are available and being made available by those companies, it's something that they can look at as well and highlight. So I do think that there's possibilities for us to do joined up work with the Home Office and with DCIT, but we wouldn't be able to legislate for the actual for whether or not they can create the apps or keep pace with that. It would really be for us to say that if anybody does that in this jurisdiction and tries to amend it to do things or make it an app to do things, they'd be liable here. Okay. If they happen without this jurisdiction and they're shared on the internet, that's something we can't do anything much about.
And we bring the offences within scope of the priority offences in the Online Safety Act, which means that they're caught and they have to, the organisations, the service providers have to take account of their actions and do more in bringing it down. And the Crime and Policing Act also reinforced the Online Safety Act, which is across the UK, in terms of bringing images down within 48 hours.
Okay.
The other thing I would add is, I suppose, the need to try and future-proof this legislation as much as possible has been one of the reasons for the delay in us getting the response out. We have tried to grasp this at a point where, at the most, I suppose, optimal point that we can do that. And the only other thing about keeping in contact with the private sector is, I have no doubt we'll be back here with some need to update this legislation, because it might not even be the private sector, it might be somebody in their bedroom creates a new app. And that's, again, it moves so fast, so I've no doubt we'll be back.
And what we would want to do as well, and some of the issues that have come out of looking at the definition, is that it's not just AI generated. We can see that the majority of this will be, because that's what young people use, but there could be gaps in the legislation where someone does it, a hard copy of something, a poster, posting something, a photograph, to someone, the post. We covered that pretty much with the cyber flashing offence, where someone could set it down for someone to pick up or whatever. So, there are other ways in which perpetrators can get out of it. So what we would want to do is future-proof it as much as possible and keep it as not as tight but as comprehensive as possible in addressing the harm. But it's the harm that is very, very important, and the level of harm that we're working through all of the various scenarios.
Thanks very much.
Ciara, you can put your soundtrack on now if you want. But can I suggest something more dramatic? Go on ahead.
Once again, I apologise. My phone's on silent.
House in the Prairie?
It was something. No.
Last of the summer wine. So just before you go into your questions, Ciara, I'm thinking that Doug would be Blairmere because he was a retired army. I would be Cleggy because I'm the most level-headed here. And I'll allow you to choose, Minister, whether it's Patsy, Brian or Morris, who's compo.
Stan had you as compo.
Be careful.
I would have had him as compo, to be fair, so...
Go on ahead, Ciara. Yeah. See if you've started.
No, once again, I
thought you were going to ask me who was Laura Bannon.
I clicked on it, and that's what I went straight into the video. My phone is on silent, so apologies.
Answer his question.
And you've already kind of highlighted the two areas that I wanted to ask, and because there is a proliferation and it is urgently needs to happen, so I really, really appreciate all the work that you are doing, and I'm really hopeful that it is within scope, as you are.
Well, we're doing our best.
Yeah, and the education piece was a key one for me, and particularly RSE and stuff. It's critically important, particularly for young people, to plan for the future, that they're educated about, given that it's about the use of them and not necessarily the apps themselves. It was just one, and you mentioned quickly to Patsy there on regards to the penalty or the sentences for the proposed offences. Could you maybe highlight or give us some understanding now at an early stage what that actually looks like, and do you believe that they're proportionate? Just to have a general idea. I think, Minister, you mentioned five or more.
Well, that was talking about, that was on indictment, it was 5 years, a fine, or both. Yeah. Two years of fine indictment. For indictment, and summary conviction, it was 6 months. 6.
Yeah, so I suppose it's maybe worth just taking through briefly the various stages. So We're proposing a creation offence, so that will include a summary-only base offence of intentionally creating or intentionally requesting the creation of a sexually explicit deepfake image without consent or a reasonable belief in consent. There will also, under creation, then be a hybrid offence of intentionally creating or requesting the creation of a deepfake image with the intention of causing humiliation, alarm, or distress, and a further hybrid offence under creation of intentionally creating or requesting the creation of a deepfake offence for the purposes of sexual gratification. And then, so that's under creation, and then under sharing there will be 4 further offences, and then the penalty, the summary only offences, there'd be a maximum of up to 6 months imprisonment or a fine for summary, and then for hybrid, maximum penalty on indictment of up to 2 years imprisonment. The other safeguard we have is that within the department we always screen, and not just for ourselves but for all departments and indeed members' bills, if there's going to be a creation of penalties or offences, we screen them just to make sure that they are proportionate and consistent with the existing legislative framework. So that function sits with us incidentally as well. So we will make sure that what's created here will be within the overall framework.
We based it very much in our consultation based on the upskirting, downblouse and cyber flashing, because that's the level in which the penalties are set within the Sexual Offences Northern Ireland Order, so that's within the Sexual Offences Order. And during consultation we went out specifically on that, and I know Mr Beattie had raised this just prior, when we gave evidence prior to consultation, but there wasn't anything, aside, I know Mr Beattie did respond in that capacity, but there wasn't anything that suggested anything higher, or that, you know, that it was very sort of, there was nothing in the consultation responses that would give us any sort of lever to go outside of that particular threshold.
No, that's fine. No, thank you.
Okay, that's everyone. Yep, that's everyone who wants to answer questions. So again, Minister, thank you very much for coming here. This has been our last session before recess, so it's good to have you here on this very important issue. So thank you, and I wish you and your officials all the best in the coming months, trying to get the form of words and get it to us as quick as you can. Thank you.
Well, we will. And Mr Chairman, it would be remiss of me while I'm here not to say thank you to members of the committee and to the committee staff. It has been an incredibly busy last few months, notwithstanding all of the other busyness that there's been as you were going through the committee stages of the bill and so on. And I know that there will be more legislation, as you know, now with the Victims and Witnesses Bill, but I do want to say thank you for all the work that's been put in over the last year, and for the collaborative way in which we've worked between the committee and the department. I think it's been really helpful and productive, and with what we can get to you, we will get to you as early as we can, because I actually value the role of the committee in scrutinising this, which is one of the reasons I didn't want to put something in at further consideration stage that would have really restricted any ability for us to get your feedback, because there may be things that you see or are concerned about that we and even OLC will not have considered, and if that's the case, it's important that we hear that and are able to respond to it. So thank you, and I hope you all enjoy recess. I think you've earned it, I have to say, after what has been a busy few weeks, even in the chamber. So thank you very much.
Thank you, Minister. Okay, members, moving on then to agenda item number 8. The SL1, the Justice 2011 Act Amendment of Schedule 3, Order Northern Ireland 2026, update to football bodies, championships and leagues. Can I refer members to page 194 to 215 of the meeting pack for the relevant papers? Can I remind members that the Department proposes to make a statutory rule to amend Schedule 3 of the Justice Act Northern Ireland 2011 to update references to football bodies, championships and leagues in relation to regulated matches for the purposes of Part 4 of that Act. The rule will be subject to a negative resolution procedure, and the Department is aiming for it to come into operation as soon as possible and prior to the start of the new football season. At the meeting on the 14th of May, the committee agreed to issue a call for views on the rule via the citizen space. No responses were received. The committee also sought the views of the Committee for Communities, given that the Department for Communities' responsibility for the policy provisions in the 2011 Act. That committee indicated that they had considered the changes to be in line with updating of the names of the football bodies and no comment to make. Can I remind members then that at the meeting on the 4th of June, the committee considered correspondence from Mr Bryson raising a number of questions on the proposed statutory rule, and members agreed to seek the Department of Justice in liaison with the Department of Communities for a response to the points made. The committee also agreed to ask the Department for further clarity about leagues not listed in the proposals and if banning orders from other leagues in England, Scotland and Wales would apply to Northern Ireland and vice versa. Can I inform members that the committee has now received a response from the Department on each of the matters raised by the individual and the committee's questions, which begins at page 205 of the meeting pack. So can I seek members' agreement to forward the Department's response to Mr Bryson for information? Agreed?
Agreed.
Can I just say then, members, that I'm still not content that they have actually answered all of the question that Mr Bryson had put down. I do feel the need that I think we need to receive evidence on that, and that will be from the department and then maybe Mr Bryson, who does seem to be an expert in this field. There is an issue though with regards to the pending court case, and so I think at this stage I would be seeking legal advice as to whether we can take evidence from someone who is involved in a legal process at this stage. So before we do anything or make a decision, I'm not happy with the evidence we've got to date. The members may have other views and we can hear them certainly, but at the first instance I would seek legal advice just on if we can receive presentation and evidence from Mr Bryson, who is involved in the actual court case itself.
I would agree with you, Chair. Whatever the merits or demerits of that is, whether he's an expert or whether he isn't, taking evidence on a case that is potentially before the courts, I think we would be we'd be getting into very tricky waters.
Mm-hmm. And that's why I seek legal advice then before we would actually do that. Would members agree to that?
Okay.
I think it would be very wise for us to seek the legal advice before we make any decision on who we get evidence from with regards to.
Sorry. Sure, just to clarify, it's the broader question about whether while a case is stayed that you can receive, not about the actual people involved in it, rather than the actual fact that Okay,
members agreed then? Okay, agenda item number 9 then, SL1, the Justice 2011 Act, Amendment of Schedule 4, Order Northern Ireland 2026, Expansion of Out-of-Court Disposals. So can I refer members to page 216 to 243 for the relevant papers? Can I remind members that the Department of Justice proposes to introduce a statutory rule to allow the PSNI to issue penalty notices under Part 6, Chapter 1 of Schedule 4 for a broader range of offences. The proposals will add 4 additional offences and increase the penalty amounts for offences as set out in the SL1. Can I inform members that the rule will be subject to the draft affirmative procedure and is proposed to come into operation the day after the order is approved by resolution of the Assembly. The call for views on the proposed rule opened on the 5th of June and closed on the 17th of June, and no responses were received. The committee also agreed to seek the views of the Department and the PSNI on what the impact for the scheme may be, if not including the offence of assault on a police officer in the final list of offences in the expansion of out-of-court disposals. The Department response begins at pages 240 of the meeting pack and is in the meeting pack, and the Department advises that based on 2024 figures, the decision not to include the offence of assault on a police officer affects an estimated 89 cases per year, representing less than 1% of the total number of magistrate court cases. The PSNI's response found at pages 7 to 10 of the table pack. It advises the impact will be continued demand on resources in relation to lower level assaults for the police, PAPS and courts, reduced flexibility for minor offending and fewer opportunities to deliver swift and certain outcomes in appropriate cases. The PSNI has also welcomed the committee's support for the expansion of out-of-court disposals to the 4 other offences included in the SL1. So can I ask members if they are content that they now have enough information to make a formal decision on the proposed rule, and if any further information or clarification is required at this point? If there are no other clarification or information sought, can I ask members then if they are content with the proposal for the stat rule? Content? Okay, thank you members. Agenda item number 10, SL1, the Coronavirus Act 2020, my old friend, extension of provisions relating to live links for courts and tribunals. Number 2, Order Northern Ireland 2026. Now for members to page 244 of the meeting pack. Can I advise members that the Department proposes to extend the live links provision for courts and tribunals for a further 6 months until the 25th 4th of March 2027. So can I ask members if they are content that in line with the process for the scrutiny of delegated legislation, the committee issues a call for views on the proposed statute rule using the standard survey. It publishes the SL1 and the draft copy of the proposed statute rule on the committee's website, and then lastly considers the proposed statute rule at the meeting on the 10th September 2023. Can I ask members if they need any other information at this stage, or are they content to proceed? Content to proceed? Okay. Can I advise members that I intend to group agendas 11, 12 and 13 together, which is the commencement of provisions in the Offensive Weapons Act 2019. Can I refer members to page 258 of the meeting pack for the start of the relevant papers? Can I inform members that the Department proposes to make 3 statutory rules relating to the commencement of provisions in the Offensive Weapons Act 2019 to make it a criminal offence to possess certain dangerous weapons in private. Members may wish to note that the SL1 advises that the rules will be subject to draft affirmative procedure. However, the commencement order will not be subject to any procedure. The Department has been asked to provide a revised SL1 to clarify this. Can I ask members if they are content that in line with the process for the scrutiny of delegated legislation, the committee issues individual calls for views on each of the proposed statutory rules using the standard survey, publishes the revised SL1 and the draft copies of the proposed stat rules on the committee's website, and then lastly consider the proposed statute rules at a suitable meeting following the summer recess.
Yep.
Agreed? Thank you, members. Agenda item number 14 is reform of the Legal Services Department of Justice written paper. Can I refer members to page 306 of the meeting pack? The Department has provided a summary report on a recent stakeholder engagement exercise to explore potential reforms to legal aid, which focused on ensuring legal aid remains fair, effective and targeted at those most in need. The Department advises that work is ongoing to determine which proposals should be further developed and taken forward to formal public consultation. So the report provided is therefore for information only and reflects ongoing policy development with no final decisions having been taken. In view of this, the Department has asked that members do not share any further with stakeholders at this stage. So just let me repeat, members are not to share this item with stakeholders at this stage. Can I ask members if they're content to note the paper? Okay, thank you. Agenda item number 15, access to the bar, a raised paper, written paper. Can I refer members to page 322 of the meeting pack, which contains a research paper commissioned by the committee on the process for accessing the bar here and in other neighbouring jurisdictions, and for details of any support or sponsorship offered in this regard. This followed correspondence from an individual raising concerns about how difficult it is to access the bar here. Members will recall that the committee wrote to the bar and the Department of Justice, Economy and Finance on this matter, and the bar invited the individual to contact them directly. However, members weren't content with the departmental responses and therefore commissioned this raised paper. So can I ask members if they have any comments or if they are content to note the paper, first of all? Agreed? Can I then seek agreement to forward the research paper to the individual who raised the concerns to the committee in the first instance? Okay, thank you, members. Agenda item number 16, correspondence. Can I inform members that there is a correspondence memo and 19 items of correspondence from page 357 to 925 of the meeting pack, and then 3 items in the memo at pages 11 to 24 of the table pack. Can I advise members that I will draw their attention to 10 items, and that's simply because it's the end of term, and then members will then have an opportunity to comment on the other items. 16.4, can I remind members that at the meeting on the 21st of May, the committee considered correspondence from the Neurology Justice Collective to the Minister of Health, which was copied to the committee, and agreed to forward correspondence to the Department of Justice for comment on the issues raised. Can I inform members that the Department has provided a response at pages 364 of the meeting pack? So can I seek members' agreement to forward the response to the Neurology Justice Collective and to the Committee for Health for their information? Agreed. 16.8 then, can I inform members that Stinny has provided the committee with a copy of its recently published review of the effectiveness of arrangements to assess and manage the risks posed by terrorist risk offenders by the multi-agency review arrangements, which is MARA, which is at pages 384 to 455 of the meeting pack. The report makes 3 strategic recommendations and 5 operational recommendations. So can I seek members' agreement to seek responses to the report's findings and recommendations from the MARA Strategic Management Board, the NI Prison Service and the Department of Justice, and then His Majesty's Prison and Probation Service? Agreed?
Agreed.
16.9 then, can I remind members at the meeting on the 14th of May, the committee considered correspondence from an individual regarding a proposal to introduce interim lump sum payments, or orders, in financial remedy proceedings in Northern Ireland. Members agreed to forward the correspondence to the Department of Finance and the Department of Justice for a response to the proposals and the points raised. The Department of Justice advised that it is a matter for the Department of Finance. The Committee for Finance has also asked the Department of Finance for an assessment of proposals contained in correspondence from the individual and has forwarded that Department's response for information, which is at pages 457 to 458 of the meeting pack. So can I seek members' agreement to forward the response to the individual who originally raised the matter with this committee? Agreed? 16.11 then, can I refer members to page 720 of the meeting pack, which contains a request for views on the Regional Balance Bill from the Committee for the Economy. So can I seek members' agreement to provide a nil return to the Economy Committee on that bill? Agreed? 16.12 and 16.13 then, can I refer members to page 721 of the meeting pack, which contains a request for views on the Hunting with Dogs Bill from the ERA Committee. Can I inform members that the committee has also received separate correspondence at item 16.3 from the Countryside Alliance Ireland, expressing a number of concerns in relation to aspects of the bill and its accompanying documents. CAI have also advised in their correspondence that they have requested legal opinion on the bill from the former Attorney General for Northern Ireland, John Larkin KC, and his opinion has identified serious concerns which Countryside Alliance believe the Committee for Justice is duty bound to address before the bill proceeds any further. Members will be aware that the scrutiny of the Hunting with Dogs Bill including those issues raised by CAI correspondence, is a matter for the Committee for Agriculture, Environment and Rural Affairs. So, Patsy, you want to come in first before I move on with actions?
The author seems to have got a bit mixed up, thinking we're some sort of a legal oversight committee for other committees within the Assembly, and we're obviously not, and you made the point. This isn't a matter for this committee.
Yeah, that's fine. Thanks for that, Patsy, because that's exactly my position too. So can I seek members' agreement to forward the Countryside Alliance correspondence to that committee, recommending that they may wish to, that when I say that committee, I mean the ERA Committee, recommending that they may wish to engage with the relevant organisations in the justice sector on the issues raised, for example with the PSNI about operationalisation of the legislation, the PPS about the reverse burden of proof, and the Department for Justice regarding the proportionality of penalties, etc. Are members content? And then can I seek agreement to advise Countryside Alliance of the action that the committee has then taken? Agreed? Agreed. And with regards to the ERA Committee's call for evidence, can I seek members' agreement to ask the Department if it has any comment to make on the bill? Agreed? Okay, moving on then, 16.15 and 16.16. Can I refer members to page 731 of the meeting pack? Can I advise members that they will be aware that over recent months the committee has received a significant volume of correspondence relating to the police injury on duty. At the meeting on the 4th of June, members considered further correspondence from two individuals requesting additional information, and it was agreed that committee staff would take time to evaluate the correspondence to determine if any questions had previously been answered before forwarding any further correspondence to either the Department or the Policing Board. This work has now been completed, and the questions asked in the most recent correspondence from each individual has either not been asked previously or additional information is being requested further to previous responses. So, having said that, can I ask members then if they are content that the committee forward the additional questions from the correspondence considered on the 4th of June to the Policing Board and the Department for their response, along with additional questions relating to version 3 of the joint guidance, which are on page 750 of the meeting pack. Agreed? Content? Can I advise members that in addition the correspondence from the individual at item 16.15 also requested information on the committee's scrutiny of a statutory rule which placed the joint guidance for medical practitioners on a statutory footing. A draft response to that correspondence has been included in pages 733 and 734 of the meeting pack for members' consideration. So can I ask members if they are content that that draft response be issued to the individual? Agreed? Thank you. 1619 then, can I refer members to page 721 of the meeting pack, which contains correspondence from an individual with communication difficulties in relation to their experience of access to justice for vulnerable patients in family proceedings. The individual has shared of their own experience of registered intermediary to them in areas of communication and understanding of the family's proceedings court. Can I seek members' agreement to forward the correspondence to the department with the individual's permission to seek confirmation of what support is available and what is being done to ensure people with communication difficulties can fully participate in the family court setting? Agreed? 16.23 then, refer members to pages 18 and 22 of the table pack for a copy of the letter from PIP's Suicide Prevention Ireland to the Northern Ireland Policing Board. This correspondence raises several concerns about right person, right care, following a recent serious incident involving a person at risk. So can I seek members' agreement to ask the Policing Board for a copy of its response to PIPs on these serious matters? Agreed? Here, you want to come in?
I would be very keen that this is also sent to the Department of Health and the Department of Justice for comment. I know I've put on a few questions myself and I have been kind of monitoring it, but there does seem to be a lack of clarity as to what parts are operational and what parts aren't. And I know we were kind of we done a joint meeting maybe 2 years ago on the whole right care. Have we scheduled? We had scheduled to do a joint meeting with them again, have we, on it?
Sorry, Chair, it is something that the committee had asked for, but it's just been so difficult with the schedules for both committees to get something arranged.
Maybe just we write, as a committee, we write to the Department of Justice for an update on exactly where it's at and what is operational and what's not, and a response to this as well, because I'm gravely concerned, to be honest. In principle, yes, it's good, but I need to ensure that it works on the ground and the resources are there. But if the C&V sector don't feel that they've been part of, and that's concerning.
Yeah, understand. Okay, members are content then to move as Ciara has described there. Can I ask members if they're content to note the other items of correspondence, or if any set out in the correspondence memo of the meeting pack, or whether anybody wants to raise any other issues? I have not. Okay, moving on. Sorry, Aoife, come on ahead.
Any other business? Yeah, sorry. So
not yet. No, we're not there yet. Don't worry. I'm going as fast as I can, but I'm just not that quick. Agenda item number 17 is Forward Work Programme. So can I refer members to the latest draft of the committee's Forward Work Programme, which is at pages 926 to 936 of the meeting pack. As members will note, a number of oral evidence sessions on the sentencing bill have been scheduled for September, early October. There are some sessions still to be arranged, and committee staff will continue to work on scheduling over the summer recess period. During the discussions on evidence gathering for the sentencing bill, it was suggested that the committee may wish to hold a round-table event. The members will recall that previous round-table events were held during the committee's normal weekly meeting slot. However, only availability for the Long Gallery will be later in the afternoons of Thursday the 1st of October and Thursday the 8th of October. Now, as members will see from the Forward Work Programme, these three evidence sessions on the bill have been scheduled for the 1st of October, and whilst it shows that the deliberation should begin on the 8th of October, we may need to take further formal evidence that day also. So if members wish to proceed with an informal round-table event, it will need to take place on the evenings or on another day, subject to the availability of the Long Gallery. So can I take members' views on whether they wish to hold a round table event then at this stage? What's your thoughts or views? Now, Ciara, you had raised this.
It's probably the jury's out on this, because I know it's additional time and I know we're under pressure. So it's supposedly it's constantly reviewing it, who has been able to come regarding presenting evidence, and if we then feel that there's a cohort or a group that haven't been able to come to committee and very much are keen to actually meet with committee and discuss, then we may have to try and maybe do an evening thing. But it's more so just to ensure that all those that are keen to present evidence get the chance to do it in a comfortable environment, you know. So
I suppose the issue for us then is getting the time, getting the venue, and having the time then that members then partake of that. Because we would want members to be there, and we're all stressed with other times and other committees and our commitments. So it might prove very, very difficult to actually get something penciled in. That's the only thing. And before we would start going about inviting groups to something that maybe isn't going to work. That's our only worry. Clark, you
Chair,
want to?
just through you as well. I think slightly different to the Justice Bill, we're probably, the committee has scheduled to hear from more, a broader range of groups as well on the Sentencing Bill that maybe weren't up in the Justice Bill too, so there would be a broader range of formal evidence this time as well.
I thought that when I seen actually even the spreadsheet of who's been invited out, it's very comprehensive. So
are we prepared to park that then?
I'd be content to park it for now. And if we then thought that there's a cohort of groups that are keen to meet with us and would be important to meet with us,
facilitate it through that, guys.
we could then maybe, but at this moment in time,
Okay, thank you. Agenda item number 18 is chairperson's business. Can I then advise members that it is standard practice to delegate authority to the chairperson and the deputy chairperson during periods of recess to submit views on the releasing or withholding of information in any non-routine or contentious freedom of information requests received by the committee, and that any such views expressed would be brought to the attention of the committee at the first meeting after summer recess. So given what I've just said, can I seek the agreement of members to this? Agreed? And then correspondence. Can I advise members that correspondence will continue to be received over the summer period? This is usually provided to the committee for consideration at its first meeting after summer recess. The committee team will advise members if any urgent matters arise on any matters that may require agreement via correspondence over the summer period, and in any such instance will be included in the minutes of proceedings of the next formal meeting of the committee. Is that agreed? Members happy enough? Can I also take this opportunity as chairperson of the Justice Committee to congratulate Connie? She is getting married next week. Would you believe it?
That's what I was going to say.
Sorry if I stole your thunder. Chairperson's prerogative there. So, and just as chairperson, could I thank Connie for her contribution to the Justice Committee, even though she was so busy organising her wedding over the last year, and wish her all the best for a big day and for the future.
I really appreciate it. Oh, thank you guys. That's so kind. Thank you. What date is it? Wednesday.
Oh my God, why are you here?
That's a week to go. I know.
Nerves starting.
Oh yes. More about the organisation, not about him, but the organisation.
Very good. Very good. Very good. Well, we wish you all the best
Thank you so
for the day and for the future. Okay then. That's all right, Brian.
Sorry, I can't follow that. This is very mundane. But just the earlier briefing.
You get married.
I meant to say earlier, we had with the Minister on the Deepfake sexually exploited images. I know I haven't received the amendment yet, but whether we could request a raised paper on what legislation does exist elsewhere, just that they could be working on that,
Okay.
Because you mentioned England, Wales, Australia, America, and so on.
It's not a bad idea, actually. Yeah. Okay. Well, you've examined any of our business there, Brian. But does anybody else get anything? No, I've stole the Ethan's.
You stole the thunder.
It's alright. Once it's remembered, it doesn't matter. It's alright.
Agenda item number 20 then is date, time and place of next meeting. Can I advise members that this will be the last meeting unless urgent matters arise until after summer recess, and the next meeting will therefore take place after the summer recess on Thursday 10th of September 2026 at 2 p.m. in room 30 Parliament Buildings. I adjourn the meeting.